Let's come back from the lunch break, please. Mr. Armstrong, would you join us again? Ms. Fox or Mr. Tisdale?
Yes, Madam Hearing Examiner. Just a few questions for us. Good afternoon, Mr. Armstrong. My name's Kyle Tisdale. I'm an attorney with the Western Environmental Law Center representing the applicants in this matter. Really just a few questions for you. You do have your direct testimony with you, is that correct?
I do not.
Okay, we can probably pull it up for you then. And really the point of the questions is just to clarify some of the things that I heard in the summary of your testimony and then some of the things in your written testimony as well. And I know some of the well numbers are moving targets, right? So I recognize that, and I'm not trying to pin you down on any exact number. I'm just trying to understand a little bit more those wells relative to just the testimony to try to understand what some of those thresholds are for purposes of the rule. So I think you had a demonstrative slide in your testimony that identified 75 active wells, but I think I heard you say that you had 70 currently active. Is that right?
That's correct. Going back and looking at it, it was fewer than the initial number that I had provided.
Okay,
so
great.
And that's approximately 66 active producing wells and then a handful of injectors and SWDs.
Oh, so 70 total wells, maybe 66 currently in producing at some level.
Correct.
Okay, great. And then your testimony as well, both your written testimony and then orally, you talked about the marginal well status. And so is it your understanding there's been some confusion from prior witnesses around what the actual threshold was for their testimony, what they were applying, right? I think you heard that. I heard from you that you were available to hear some of that testimony, but maybe not all from prior witnesses, but there has been some confusion. So I just want to understand, when you're speaking of marginal wells, are you speaking about the thresholds as defined in the proposed rules?
That would be 1,000 BOE and 180 days of production. And
yes.
180 days. Yes.
Okay, wonderful. And then I think Ms. Fox is going to pull up a portion of your direct testimony, and this is specifically at the bottom of page 5 going into page 6, I believe. Yeah, and you can see that testimony there. Looks like actually the bottom of 6 going onto the top of 7. But that testimony essentially says that you have 5 currently wells in marginal status. Is that correct? I think that 5 well count is on the top of page 7.
That states 7 wells on the Hoover lease produce into a common battery. 5 of those wells be considered marginal as a result, not 5 in total as to those Hoover wells.
Okay. And then, so 5 of the 7 would be in marginal status? Is that what I'm hearing your testimony to be?
I believe that to be the case. I think as you have indicated, there was some confusion around what was being calculated and on what basis. Without being able to go back and look at each specific well as the number of days produced or volumes, I imagine some portion of that would still be considered still be considered marginal. The 5, I think at the point that was drafted, I understood the rule a little bit differently than it's been discussed since.
Okay. And then on the sort of first highlighted sentence there, discusses, I think maybe a subset of those wells, right? Or maybe just the 7 that you're talking about subsequently, but that those wells were shut in for 117 days out of the first 180 days of the year. Do you see that?
I do.
And you're aware that the days threshold for marginal status is over the course of a full 12 months. And so this would represent half a year of production.
It is not clear to me if we're talking about a calendar year as to that 180-day production, or if it's a constant look back. That has not been clear to me from my reading of the rule. So if what you're trying to get at is we produce the rest of that year, would we be over the 180 days? I think that perhaps could be true, but if it's a look back, then we would not be in compliance. Actually, not would be compliance. I'll say that. We would not reach the 180 days.
Okay. And you had stated you are paying surety on currently on the wells that you have, correct?
Correct.
And I think you discussed your premium right now on surety is at 3%.
That's correct.
Okay. So if we took those 5 wells that you're defining as marginal here, and assuming that each of those would need $150,000 single well financial assurance, that would be $750,000. Does that sound right?
In my understanding of math, I think that would be the case, which is always questionable. But again, that 5 wells only pertains to that group of wells.
Okay. All right. I also heard in your testimony that since 2019, you had plugged 16 wells. Is that correct?
Yes, sir.
Okay. And your average cost of plugging those 16 wells was $120,000. Was that correct?
That is the 4 wells that we have plugged over the last 2 years. Once prior to that, I couldn't speak to what the cost of those were. We didn't look that far back because we thought the more current information was better. And
sure,
that's the figure we're using for some wells that we're planning on plugging.
Okay. And then for the 16 wells, if just assuming that $120,000 figure is roughly equivalent across for those 4 wells would apply to those 16, that would be about $1.9 million that you expended in plugging costs. Does that sound about right?
I'm not going to be able to do the mental math on that, but I'm assuming you have, and that's correct.
Okay. I'm not going to get into a math contest with you, certainly, because I think I probably would lose that one. But I think my simple lawyer math suggests that sounds about like the right average. And then I also heard from your testimony just relative to across your operations is that you have several wells that are sort of higher producing wells, and that the higher production from those wells sort of sustains your operations. Is that a fair
If I use the word
characterization?
sustain, that's probably not the most accurate word to have used. I mean, they certainly create more of the revenues, more of the net revenues than do the marginal ones. But
yeah,
many of the marginal, at such point as we can't make money on them, we tend to plug them. So
okay.
The marginal wells that are still in production are contribute to our bottom line.
Okay. But is it a fair characterization to say that the higher producing wells sort of carries the bulk of the water for the wells that are maybe more marginally producing or lower producing?
That's probably fair.
Okay. And then so for the wells that you're plugging, I want to understand a little bit more how you are paying for those wells. Are you paying for those wells out of, do you have a special fund that is set aside to pay for those plugging expenses?
No, we pay for plugging out of cash flows and existing cash on hand, but we have not designated funds for plugging purposes.
Okay. And that's fairly typical across industry, right?
As to my understanding, yes. Others may handle it differently.
Okay. And so the higher producing wells that you have a really meaningful impact on your ability to plug those wells, right?
They certainly contribute. Again, we try and maintain a good cash balance
Yeah.
that we can plug out as necessary or take advantages as those come up. Or we do have a line of credit that we can utilize if existing cash on hand was not sufficient. But over 44 years, that hasn't happened yet.
That's great. And you wouldn't be able to, if you were only had a fleet of marginal or low producing wells, you wouldn't be able to plug those wells in the absence of some of the higher producing wells that you have. Is that fair to say?
Objection, that's speculative. Madam Hearing Officer, that's going into the economics of an individual well analysis and pulling numbers out of the air.
Mr.
believe-
Armstrong, if you can answer it without speculating, go ahead. Otherwise, just say so.
I would say we've never been in a situation where we suddenly have to plug every single marginal well at the same time. And I'm
Sure.
generally unaware of situations where that's occurred with others. I'm sure there have been some, but we would have sufficient cash flows to continue operations and until such time as additional wells are required to be plugged.
Okay.
Mr. Tisdale, 5 minutes.
Okay. I actually don't think I have any further questions. Thank you, Madam Hearing Officer.
All right, thank you, Mr. Tisdale. Mr. Tremaine or Mr. Hall?
Mr. Train, thank you, Madam Hearing Officer. Good afternoon, Mr. Armstrong. We've met in passing in the past, but I'm Jesse Tremaine, OCC's legal director. I want to share screen here and ask you a couple questions. I'm going to start out right on your rebuttal slide number 4. So there's 14 wells listed on this slide, right?
That's correct.
And this is wells that you pulled that you felt would be at some point in time in the year 2024 would have fallen into the marginal well category as defined, correct?
Potentially, yes.
Potentially. Okay. So these 14, 2 of these wells were plugged sometime in 2024. I understand that, right?
That's correct. The 2 Hillburn wells.
Okay. And thank you for that. Down here, it says wells with less than 1,000 BOE during 2024. Did you use the and for the 180 days in generating this list of 14 wells?
There were a couple other slides that I think indicated the 180 days. I think it is possible that some of these produced in excess of 180 days.
Okay.
Part of the challenge in identifying those is, and we followed up with the OCD last week to confirm this, we have been told when we report production, if we have a well that produces a certain number of barrels in a month, we report that as a 30-day production, not 2 days of production, not 3 days. So I think that would certainly be a challenge for me to go out and pull out which ones actually, in fact, produce that 180 days versus, and certainly not information that the OCD has requested till this point.
Okay. So this refers to 2024. Is this based on production data for calendar year 2024 or New Mexico fiscal year 2024?
Calendar year.
Calendar year. Okay. Did you prepare as an exhibit or provide the calendar year 2024 data that is the basis of this slide?
No, I had one of our engineers compiled this, so I don't believe I saw the raw data from it.
Well, so the record's not going to reflect that data to double checks, but we have the fiscal year 2024 data. So I'm going to point you to that in a second. But first, I want to ask you about, my thing's getting in the way. Applicants exhibit 1A. This is page 8. Bates 8. It's page 15 out of 955. And trying to belabor this, but if you could just please read the definition of marginal well at M2 for the division.
Certainly. Marginal well means an oil or gas well that produced less than 180 days and less than 1,000 barrels of oil equivalent within a consecutive 12-month period.
Okay, so Mr. Armstrong, as you read that, that refers to oil and gas wells, correct?
Correct. The BOA would indicate that there's some conversion from gas to oil.
Does that definition include injection wells?
It does not.
And does,
As I read that now, no, it does not.
and does that definition include saltwater disposal wells?
No, it does not.
All right. So I'm going to refer you to page 32. And nope, sorry, it's page 32. It is page 39 of the same exhibit. And I just want to point out and confirm here in the proposed definition under presumption and no beneficial use, would you agree with me that the 25.9A refers to production wells?
Objection, Madam Hearing Officer. Mr. Armstrong has not offered direct testimony on the presumptions of no beneficial use provision in the proposed rules.
I'm just asking him to help walk through and clarify the various sections. He's making a claim that there are 14 wells that fall under a marginal definition, and I'm pointing out a distinction in the rules.
All right.
I'm not quizzing his legal knowledge.
All right. So again, Mr. Armstrong, if you can answer the question, please do.
Could you repeat the question?
Okay,
Hannah.
thank you. When you look at 25.9A here, does that section, as you read it, refer to production wells, oil and gas wells?
As I read it, yes.
Okay, and 25.9B, does that does that refer to injection or saltwater disposal wells?
It does.
Okay, so the previous section that we talked about, the definition of marginal wells, does not include any definition, does not include injection or saltwater disposal wells, but the presumption of no beneficial use does include a separate section related to injection or saltwater disposal wells, correct?
That's correct.
Okay. Bear with me here. So I'm going to go and look at OCD replaced exhibit number 16. And this was distributed. So I'm opening it from the distribution email here. I'm going to click enable editing so I can unlock it. And we're going to go to review. And just let I'll make a proffer for the record that I shared the password with all the parties here. So I've unlocked the sheet, so now we can filter it, okay? So I'm going to do Control All, and we're going to go up to the top so we can see these. And then I'm going to click on Data, and I'm going to click on this button Filter. So I've done no Excel magic. This is lawyer Excel use, which is always questionable. And I'm going to go in here and filter into the OGRID name Armstrong. Okay, so here, would you agree that we have one Armstrong Energy Corporation that pops up?
That's correct.
Okay. All right. So I'm going to go over to BOE and we're going to do less than 1,000. And now we have 21 hits. But let's look at days in production. And I'm going to click everything here, clicking 0 and 155. The others are 304, 360, and 366. All right. So based on this, I get 7 wells. And I want to walk through here because now on your slide 4, you have 14 wells. And you have them by well name. This sheet has wells by API. So I'm not going to be able to do a direct comparison of which well is which well. But I just wanted to confirm here that 3 of these wells are injection wells. Is that accurate?
That's what it indicates here, yes.
Okay. And 2 of these wells are saltwater disposal wells. Is that accurate?
According to what it says here, yes.
Okay. So according to OCD's FY24 production data, Armstrong Energy has 2 wells that would fall within the marginal well definition. Would you agree?
Without going back and looking at, I understand that there are certain thresholds under which saltwater disposal wells and injection wells can fall under that. If my understanding was correct, based on that subparagraph B that you hadn't agreed, and perhaps I
Right.
read that wrong.
Well, that was the basis of my question, was that section that we referred to was the presumption of no beneficial use. So would you agree that under the marginal well definition, which is what is relevant to additional financial assurance, injection and saltwater disposal wells do not fall under the category?
if I were to give a more comfortable or answer I'm confident in, I would need to review that a little bit more in depth to make sure my analysis of it is correct.
Okay.
I'm not, I'd need to sit down and study those a little bit. I'm a slow learner.
Okay. Okay. Well, we've already covered that part. So let's say, let's assume that my filtering job here, very simplistic filtering job here was right. And we've got 2 wells that would fall in the marginal well category. At $150,000, that would mean that Armstrong Energy Corporation had to provide financial assurance in the amount of $300,000 in excess of what you currently provide. Would you agree?
If that were correct.
Okay. And do you agree that you would have, if the current rule was promulgated, until May 1st, 2028 to either provide that financial assurance or otherwise plan for how you were going to manage or plug those wells?
I believe that's the case as it is currently written. Yes.
Okay. And do you have, we walked through, I did it the long way. I wanted to avoid any foundation concerns here. Do you have any reason to dispute what we just walked through to determine how many marginal wells Armstrong Energy Corporation would have based on the fiscal year 2024 data from OCD permitting?
Again, that prior slide that was shown was analysis that was performed in-house to look at those particular thresholds. Only looking at the API numbers, I couldn't tell you. Well, I could tell you what the injections and SWDs are, but the other 2 wells, I'd have to guess at what those are. And again, this comes back to a calendar year 2024. My understanding of reading the rule is in the prior 12 months, it does not state calendar. So some of those wells, well, I take that back because I was basing it off of 24 months. My recollection as to the Hoover well is it was shut in for 117 days the first half of the year. It was shut in a number of times after that for ongoing issues. I would have to look at that. And again, as yours here shows it, as I indicated, there are a couple of wells, the Salbar, the Chaparral, the Ruth 20, number 1, are wells that don't produce 180 days a year. For the Sundance, I believe, is another such well. But they are reported on a 30-day production because they do produce something within that month. So I'm not sure that this data captures that.
Well, let's examine that a little bit. Do
You
you
have
agree
4
that-
minutes, Mr. Tremaine.
I think hopefully I'll be 2. Mr. Armstrong, do you agree that OCD's production data, which is exported in this sheet, is reported to OCD by Armstrong Energy Corporation?
In the manner that the OCD has directed us to do it, yes.
Okay. And using that data and filtering that data, we've just came up with 2 wells. So my question is do you have any reason to dispute that based off of this data, Armstrong Energy Corporation only has 2 wells that fall within the definition of marginal?
Yes, as indicated, there are certain wells that don't, in fact, produce 180 days per year. But
okay, but
there
you
needs
have
to be clarity as to
Right.
what time frame we're reporting that as. And again, yours falls under a calendar here. And some of them don't, in fact, produce 180 days a year. We report it according to how OCD has directed us, and we confirmed that again last week.
if we just went through this exercise, so if that was captured, if those wells were producing less than 180 days per year, but produced more than 1,000 BOE, they wouldn't be present on the filter that we just did, right?
That's correct.
So I'm asking you about the definition of marginal well in its totality, and your response was that there are wells that produce less than 180 days. So are you saying that those wells also produce less than 1,000 BOE?
Yes.
Yes. Okay. But you're saying that's not reflected in the production data that was reported to OCD?
I am stating we reported production in the manner which we were told to report it. Some of those wells do not, in fact, produce every day. So they would fall under the 1,000 barrel a day, 1,000 BOE threshold and the 180-day threshold. to the best of my knowledge.
No further questions. Thank you.
Okay, thank you, Mr. Tremaine. Mr. Moore, do you have questions for Mr. Armstrong? Oh, Mr. Biernoff, it appears.
Yes, good afternoon, Madam Hearing Officer. I'm in for Mr. Moore. I do have some questions. Thank you for calling on me. Good afternoon, Mr. Armstrong.
Good afternoon.
You mentioned in your direct testimony that since 2019, you've plugged 4 wells at an average cost of $120,000 per well. Is that right?
No, and I apologize if I was not clear. We have plugged, I believe it was 16 wells since 2019. Not having my piece of paper in front of me, I couldn't tell you if it was 14 or 16. We have plugged 4 wells in the last 2 years at an average cost of $120,000. I do not have the data on those prior wells. We didn't consider it to be applicable given cost structures have changed.
Oh, okay. Well, let me ask you about that. Cost structures have changed in what way since those early days, 2019 or so?
Well, costs in general, I think have, as we all know, have gone up, and that's includes within the oil field. The state has applied new plugging parameters, which require additional plugs and cement to be placed into a well bore. So where previously we might be able to plug a well in, and I'm just going to throw general numbers out there, 2 or 3 days, because of these new intervals, we are required to wait for cement to set before we can go up to the next interval, place a plug and set it. So additional rig days, additional cement, number of different factors.
Okay, so you've described costs going up. So let's focus on the 4 wells that you've plugged in the last few years. I think you said just now average cost of $120,000 per well. Is that right?
That's correct.
Okay, do you remember the approximate actual cost of each of the 4 jobs?
I do not.
Do
I
you
don't know
remember-
if that there were any major outliers in that. I don't believe so. To the best of my recollection, I don't remember any large reclamation costs associated with those wells. There may have been, but does not come to mind.
Oh, okay. So each one of the 4 wells was around 120,000.
Well, they average $120,000, give or take. I could not tell you how much precisely.
Okay, you don't remember the range approximately?
I do not.
Okay. How deep?
I will say, to the best of my recollection, most of those were deep wells. So we were not dealing with shallow wells that may have been dramatically less from a plugging standpoint.
Okay, and that was actually my next question. I was going to ask you if you remembered approximately how deep those 4 wells were or the range of depth.
I would say on average 9 to 12,000 feet, which within a vertical well world is fairly deep.
Okay, okay. And did you testify, did I hear this right, that you have a non-operated interest in around 150 wells?
No, I apologize. I was not speaking very clearly then. It's roughly 350 wells, and those interests vary in size.
Okay. And for those wells in which you had those 350 or so wells where you have a non-operated interest, are you responsible for paying the OCD bonds?
No.
It's the operator who does that?
Who pays is determined by a joint operating agreement, which may go back some period of time. My understanding of the wells that we were in, we would not be able to, we are not able to charge that additional cost to the working interest owners. At the time that those would have been set, there would have been essentially a blanket amount we could charge for overheads, those sorts of costs. Well, one of those costs would have been bonding. That cost of bonding would increase significantly, but under the JOA, that amount that we can charge does not, it wasn't tied to changing number, a variable number, if that's making sense.
I think so. And so for the 70 or so wells that Armstrong Energy operates per your testimony, uh, any other interest holders like non-operated working interest owners, they're not paying you or contributing to you for bond costs, are they?
No, they're not. Other than what is kind of defined as a dollar figure within our JOAs, they do not contribute on top of that.
Oh, okay, okay. And I think you mentioned, Mr. Armstrong, that your cost estimate, the 120,000 cost estimate for the most recent 4 wells, that also includes remediation and reclamation costs. Is that right?
That is my understanding, yes.
Okay. And is it fair to characterize Armstrong as a good operator?
I would certainly hope so.
Well,
I
beyond
think
hoping,
we try
yeah.
to meet our obligations, and we try and operate in the, first of all, safest way possible. We try and be good stewards of the land that we are allowed to access. So yes, I would say we are a good operator.
Okay.
Not
Well, it's
perfect,
something,
but
okay, fair enough. And I'm certainly not aware of any active compliance violations against Armstrong at the moment. Are you?
I am not, or if there are any that are still open, they should have been closed out some time ago. By
Okay.
which I mean they may have not been entered into the system correctly, but we have no ongoing issues that I am aware of. No.
Okay. Yeah, me neither. Would it be fair to say, Mr. Armstrong, that
If
other
I might,
operators?
as to our own wells, might be the important clarification there.
It's a good one, especially now. So thank you for explaining that further. Um, do other operators who do have spills at their well sites and who do have open compliance incidents and who do have violations and who are not as good of operators as Armstrong is, would those operators have higher reclamation and remediation costs on average?
I don't know that I could say on average. Again, we try and be thorough on what we do. So frankly, our costs may in fact be a little bit higher than others. But I certainly would recognize that there's the potential for that. Yes.
Okay. So I think you said that the 4 wells that Armstrong plugged in the last few years those sites were all pretty clean, right?
To the best of my recollection, there was no major remediation costs. I mean, there is always some cleanup that needs to be done. Obviously, the caliche pad has to be picked up, has to be reseeded, but nothing that I would consider a major cost that would have significantly inflated the cost of that $120,000.
Okay. And so if a different operator, not Armstrong, whose site did have a bunch of spills and did have significant remediation to do, you'd expect the cost of that work to be higher, right?
I certainly think that is possible.
Okay. Thank you
There
so
are
much.
operators who, for instance, own their own equipment that may be able to remediate or plug at a lower cost basis, even if the extent of the reclamation is larger. But
Oh,
I'll certainly
okay.
concede that it could be higher.
All right. Okay. Well, thank you so much, Mr. Armstrong. Madam Hearing Officer, I'll pass the witness.
Thank you, Mr. Biernoff. I don't believe we have Ms. Nanasi. Mr. Maxwell, do you have questions of Mr. Armstrong?
No questions. Thank you.
Thank you. Mr. Rankin?
No questions.
Okay. Let's see. EOG is monitoring. Mr. Swazo?
Yes, Madam Hearing Officer, just a few questions. Mr. Armstrong, good afternoon.
Good afternoon.
I have to admit, most of my motivation for asking you questions is because I'm not sure when I'm going to have the chance to cross-examine another fellow Georgetown Hoya, so that's part of it.
There seems to be a microphone malfunction at this moment, so we'll see.
But the other part of the motivation is that I think, some of your testimony was enlightening, at least to me, in terms of understanding how these proposed rules will, operate, where the rubber meets the road, or I guess where the proposed rule meets the operator, shall we say. In your testimony, you said that Armstrong's been operating for, I think, 44 years, correct?
Company was founded in 1977, and I believe the first well we drilled was in 1981. So we had non-operated interests prior to that.
And you said that in that time you have never orphaned a well, is that right?
That is my understanding. No such incident where we have orphaned a well. Don't believe it's the
And-
case.
Okay, sorry. And despite not ever having orphaned a well, if these bonding rules and thresholds for marginal wells are passed, that would increase your costs, correct?
That is correct.
And those costs would be ongoing annual costs?
They would be operationally, in terms of operational cash flows, it would represent a premium on those bonds, whatever that premium winds up being, in addition to the collateral that we would have to put up and not otherwise not be able to access.
And have you heard throughout this proceeding the applicant's reference to an LFC report?
Yes, I have.
Okay. And have you heard them discuss what they dub as the orphan well problem facing the state of New Mexico?
Yes, I have.
Okay. And so with respect to that problem and these increased costs that you would incur, that Armstrong Energy would incur, would have absolutely no effect on the orphan well problem on a going forward basis, correct?
Yes, that would be the case as I understand it.
And so the only way that these increase in bonding amounts would have an effect on orphan wells would be if Armstrong itself orphaned a well in the future and did not fulfill its obligations. Is that right?
That would be my understanding, yes.
Okay. And is it your understanding that this orphan well problem is primarily as the result of legacy wells?
I would imagine that's accurate to say is that the vast majority are older legacy wells. There may be some that are newer that were drilled and for whatever reason not plugged, but I'd imagine that's a smaller portion.
Okay, no further questions, Madam Hearing Officer.
All right, thank you, Mr. Swazo. Ms. Tripp, do you have any redirect?
Yes, Madam Hearing Officer, but very, very briefly. So, Mr. Armstrong, I want to give you the chance, access to the OCD database. This is the OCD permitting website. And hopefully I am sharing what you see as a website.
Yes, I can see that.
Okay, and it's really tiny, but I have to go to expanded well search results. So these are all of Armstrong's plugged site released wells. That was the filter I used to get here. But I just wanted to get this on the record because you mentioned, it was your memory that these were deep wells, the last 4 wells that you plugged with $120,000 average cost, all in, including reclamation. And you can see that the measured depth and vertical depth for those last 4 wells are all greater than 11,000. Is that right?
That would be my understanding, yes, or based on what I see here, yes.
Okay, all right. So deep wells plugged at some fraction of the cost, including reclamation work here on that exhibit. So the last thing I want to do is to kind of put us all in your shoes as an operator, because what we're missing, I think, is the practicality of how this rule will work. So with respect to that group of Hoover wells that was shut in for 117 days out of the first 180 days of the year. So there you are in June 2025, you're looking at 5 wells, and they've only had the opportunity to produce 2 months, 60 days. And you only have, at that point, you would have another 180 days to make up the difference. Is that right?
Yes, that'd be my understanding.
Okay. Well, and those wells were shut in because there was a problem with the gathering system. Is that also right?
That is generally correct. There may be instances where a well gets shut in for a workover. We perform routine maintenance on them, things of that nature, but the pipeline shut in certainly was a major factor on those.
Okay, so with 5 wells and the potential that you'd have to bond them at $150,000 each, being $750,000, is there any way that you as an operator sitting there at day 181 of the year with another 184 days to go will know when that pipeline system is going to be available?
No, we get told when we have to shut them in, and we're told when we can open them back up again. But we typically don't receive much. The information we receive tends to come through the oil field gossip network more than any verifiable information from those midstream companies.
Understood. So as an operator who's trying to manage your wells and trying to plan, the fact that there could be a $750,000 price tag is a very real impact on your operations.
Ms. Tripp, would you stop leading him, please?
Yes, ma'am.
I'm not sure
I
what
will-
question to answer now then.
Okay, let me re-ask that. So from your position as an operator, you can't predict whether you will be able to produce a well necessarily for 180 days out of a remaining 180 days in a year.
That's correct. So from a budgeting standpoint, that does create some challenges.
Okay. All right. Thank you for walking through that exercise with me. I don't have any further questions for you, but the commission may have some. But
All right.
I
Thank you,
believe I've
Ms.
already submitted. I'm sorry, Madam Hearing Officer. If not, submitting Mr. Armstrong's direct testimony and his rebuttal demonstratives. I think I did that.
I believe you did that.
Okay. All right. Thank you.
Let's see here. All right. Commissioner Ampoma, do you have questions of Mr. Armstrong?
Hello, Mr. Armstrong. This is William, professor from New Mexico Tech. Thank you for your testimony today. I do have, so my first question to you, there were discussion with Mr. Shemaine about the days, the production number of days for a particular well. Can you tell the commission how the current production days are documented per OCD's instructions?
If I'm understanding the question correctly, how are we calculating the number of days we are reporting? Is that?
The number of days that a well is active or producing,
Sure.
As reported to OCD.
In consultation with the individual that handles our reporting, I inquired as to how we report a well that may not produce 30 days a month. Why is it showing as 30 days a month? She indicated that's how she has been told in trainings with the OCD to do it. She followed up excuse me, I was getting dry. Followed up last week to inquire if that was still the case or if we had been doing it incorrectly, and we were told no. If it produces within that 30-day period, reported as 30 days.
Objection. So Commissioner Ampoma, to clarify, I'm not objecting to your question. It's a good question. I am objecting to foundation. So Mr. Armstrong, okay, hearsay comes in these hearings, but Mr. Armstrong is testifying that he heard from somebody who works for him, who talked to somebody at OCD, who told them a particular thing. This is not in the record anywhere else. And I'm getting chatted concerns that as to whether this is accurate or not. So I think this is something that we can try and proffer and answer, and something that if true would need to be clarified in the future, right? But I have significant concerns with basing the record on what is based on Mr. Armstrong's testimony here, like 3 layers of hearsay. Like we are well down the path on the post office game here. And I've seen this play out before. I'm not going to provide any further commentary on that, but I have some significant concerns with that. So I would proffer that we would, I will follow up on this and we can try to provide some answer to the commission.
Yeah, but you know why I'm asking that, right? Because Deputy Director talked about we need to be more concerned and then provide more clarity as to how the days will be documented. So based on what he was saying, I'm like, then there's a huge uncertainty associated with the number of days.
I will, without testifying on behalf of my client, I don't think I can answer that any further, but I do feel that the record reflects an inconsistency among the opponents to the rule. We've heard in other testimony and rebuttal testimony that operators inaccurately represent that. No one else has said OCD is telling us to report 30 days for every month in which there's production. This is deeply concerning representation.
Okay. Thank you for clarifying because it was a concern based on the testimony. So I will not ask any further questions on that. So I'll move on. Thank you. Yeah. So Mr. Armstrong, you've talked about the impact that these rules would have on small operators. Especially you highlighted the 15% threshold that has been imposed if this current rule was going to be passed. You with me on that one?
That's correct, based on how I am calculating the 180 days. Yes.
Yeah, so there has been a lot of discussions, and from where I sit, I want to see some compromise here. So there has been a lot of discussions where there is a little bit of agreement on 30 days. Threshold, 30% threshold instead of the 15%. Would that be something that would be more appealing to prudent operators?
It would certainly be a move in the right direction. I could certainly see situations where that would be problematic. I believe, as I testified this morning, some of the packages that we have acquired inevitably include a good number of what would be considered marginal wells that might take us over the 30%. So that would therefore prevent us from acquiring that package, reworking those wells if we decided the economics did not work because of that additional bonding level or the amount of cash we would have to put up instead. But 30% would be an improvement. It still seems to me applying that single well bond to the remaining 70% will have, I won't speak for myself, but I can see scenarios in which that additional 70% is put at risk, which seems to me the opposite of what we're trying to do in protecting against the most high-risk wells. We're now making productive wells potentially at risk.
So there has been a little bit of discussion where Commissioner Bloom was suggesting, based on the discussion about providing some exceptions to the definition of the marginal wells as pertain to the bond, the 150,000. So some of the exceptions are some of the things that you've listed here. Did you listen to that discussion?
I don't recall if I heard that specific discussion. I am aware of creating some discussion around creating exemptions for some of the issues that I've discussed regarding midstream takeaway capacity. I'm aware those discussions have gone on, yes.
So would you be in a position to provide some of these to the commission for our consideration?
Some exemptions?
Yeah.
Beyond the ones that I've heard, midstream wells that are part of a enhanced oil recovery project, those certainly make sense to me and seem to be fair. That would prevent additional waste and allow us to maximize the production we can get out of those wells.
Thank you, sir, for your time. I do not have any further questions.
Thank you. Commissioner Bloom, do you have questions?
Yes, thank you, Madam Hearing Officer. Mr. Armstrong, thank you for your time today. Just back to what Dr. Mpoma mentioned regarding the issue of midstream shut-ins. So, Mr. Armstrong, your concern is that a well that would not otherwise be deemed marginal could become marginal if the midstream was shut in, if pipelines were not accessible over a certain period of time. Did I get that right?
Yes, I believe that's true.
Yeah. And last week I offered an initial attempt to get around this, and I swear I had some better language this morning in my head when I woke up, and it just gone now. But currently we're defining the proposed definition of marginal well is quote, marginal well means an oil or gas well that produced less than 180 days and less than 1,000 barrels of oil equivalent within a consecutive 12-month period, end quote. And what I might add to that would be the following. After it says, within a consecutive 12-month period, not including in this period production days lost to midstream shutdowns. So I would hope that that would extend that period out for any period of midstream shutdown and take that out of the count. Would something like that be potentially helpful?
It certainly would be helpful, and I think it would be a reasonable accommodation for a situation where should not otherwise be considered marginal. It doesn't seem to me that that's what the problem we're trying to solve here.
Okay. Mr. Armstrong, thank you for your time. No further questions.
Thank you. Chair Chang, do you have questions?
I do not. Thank you for your time. Appreciate it.
All right. Any reason not to excuse Mr. Armstrong? No. Thank you very much, Mr. Armstrong.
Madam Hearing Officer, IPNM's next witness is Mr. Gilstrap, and he is on the platform. I do think he's a technical witness, so we anticipate going about an hour for his direct and rebuttal.
All right. So perhaps then we should take a break before we hear from him. Let's come back at 2.
Thank you.
Sheila? All right. Let's come back from the break, please. I believe Ms. Tripp is calling IPA&M's next witness.
Yes, Madam Hearing Officer, and his name is Trevor Gilstrap. If Ms. Apodaca can give him camera and audio permission.
All right, thank you. Mr. Gilstrap, when you unmute yourself, there you go.
There.
Will you spell your first and last name, please?
Yes, ma'am. Trevor, Trevor. Last name Gilstrap, Gilstrap. P as in Paul.
Thank you. Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. Go ahead, Ms. Tripp.
Good morning or good afternoon, Mr. Gilstrap. We have spoken before. I want to thank you for coming to testify today remotely. If you could introduce yourself to the commission.
Yep. My name is Trevor Gilstrap. I'm currently a senior vice president and the national energy practice leader within Assured Partners. Assured Partners is an international insurance broker.
And can you tell us a little bit more about your education and your experience?
Sure. Graduated with a Bachelor of Arts in Psychology. Started my career as a claims adjuster with Farmers Insurance. Initially worked as a liability claims adjuster and then transitioned to Farmers' dedicated catastrophe team, where I handled large-scale natural disaster claims to insured autos and property holders. Have been with Assured Partners for about 15 years now.
And what is it that you do with Assured Partners in the energy practice section?
So my team provide insurance brokerage for oil and gas companies with operations spread throughout all of the oil and gas producing basins within the U.S. We are largely focused on domestic operations. We don't really touch much internationally.
And so do you have experience in New Mexico, for example?
Yes, ma'am.
Okay. And then surrounding states, Colorado or Texas, Oklahoma?
Correct.
Okay, thank you. And then we're here today on a proposed rulemaking which addresses financial assurance. Have you had a chance to review any of the statutes or regulations in New Mexico?
Some, yes.
Okay. And so I'm going to share my screen here, which I forgot to do in the beginning. Let's see here. And so this statute, which is 70-2-14, what is your understanding of the forms of financial assurance that are allowed?
That there's 4 of them: irrevocable letter of credit, cash bond, surety bond, and plugging insurance policy.
Okay, thank you. And then let me get here. Okay. And so in terms of kind of your credentials and your experience, how long have you been with Assured Partners and what kinds of clients do you work with?
Yeah, so we were acquired. I've been on this side of insurance for close to 15 years now. We were, gosh, when did we get acquired? Sorry, I wasn't ready for that. I think we got acquired in 2015-ish. So we do property and casualty insurance for oil and gas service contractors, operators, non-operators throughout the U.S. Property and casualty being anything from their liabilities, so general liability, control of well, to the bonding needs that they have. The bonding needs vary for contractors and operators, but we're handling start to finish those property and casualty needs for domestic upstream oil and gas contractors and operators in the U.S.
And so then with respect to the rules that are at issue here, the regulations, have you reviewed the proposed change in by applicants to the financial assurance requirements in New Mexico?
Yes, ma'am.
Okay. What's your understanding of the existing bonding rules?
Sorry, were you scrolling or am I answering?
Yeah, I'll let you answer. Go ahead.
Okay. That it's a blanket bond that's applicable to operators in the state.
And that go ahead. Sorry.
Oh, I didn't say anything. I'm sorry.
Okay. And that blanket bond, is there another option for a single well bond or a one well plugging financial assurance?
Yes. So once you hit a certain threshold, then it can take over and you can take advantage of the blanket bond as a more cost-effective option, I guess, for your bonding needs.
And your understanding of a blanket bond is that it covers all wells. Is that
Yes,
right?
ma'am.
Okay. Okay, and so what are some of your concerns with the proposed rule change?
Um, I have a lot. Having gone through this in Colorado, bonds it's an incredibly hard market right now for bonds. These changes have the propensity to have substantial ramifications on, I think, operators that are currently active in the state. Some of these proposed changes are going to lead to, as proposed, significant increases in the bond amounts, which is going to lead to really two meaningful changes. One, a pretty precipitous increase in the bond premiums that are being charged to these operators. So the annual premiums they're paying to have the bond in place, this promise to pay. And I also think that there's going to be some really big ramifications on the collateral tied to those bonds. The surety market it's extremely hard. It has been for several years. We're seeing collateral on the rise. So oftentimes you're looking at collateral requirements that are anywhere from 50 to 100% of that bond amount. So not only do you have these increased premium charges taking place, you're also getting CapEx constrained with all of the collateral that is also being tied up with those bonds.
Okay, and I think in your direct, you provided a few hypotheticals in terms of what would be the effect of the proposed rule for an operator. Let me get there. So in this first scenario, and you walk us through this.
Yeah, so you're looking at an operator that has 150 wells that are above the 15% threshold, and they need a $22.5 million bond. So again, typically we're seeing these increased collateral charges. So oftentimes it's going to be anywhere from 50% to 100% of that bond amount. Bond amount in this particular example being $22.5 million. So you take the conservative approach and say that the surety is going to charge a 50% collateral. That's $11.2 million in funds that are tied up. So either the operator is relinquishing those funds that are being held in the form of cash, or they are drawing down a revolver that they might have in place, which they'll get charged for that as well. And then in addition to the collateral, the surety, the bond carrier, is going to charge an annual premium. So the way that those annual premiums are calculated is it's based on a percentage of the total bond amount that is being put up. So again, in this situation, if we're looking at a $22.5 million bond, typical bond ranges in terms of premium for P&A bonds is between 2.5% and 3.5% of that bond amount. So in this particular scenario, we're looking at a collateral of probably north of 11.2 million, with annual premiums on top of that ranging between 562,500 to 787,500.
And I think you just testified earlier, but those premium ranges, those aren't set in stone. The surety, it's up to the surety to determine them, and so they could certainly increase.
That is correct.
And in your opinion, could the effect of these rules drive premium rates up?
Yeah, 100%. This is a larger exposure for bond underwriters. I think we'll probably get into this a bit later on, but bond, it's not a transference of risk. All it is a promise to pay. So as you're asking sureties to increase the promise that they're making, they are more exposed. They're not taking on that risk. They're simply promising to pay it in the event that bond is called upon. So yes, I think that we could see a fluctuation in these rates, either through uncomfortability within underwriters or a lack of capacity within the existing markets. So yes, they're subject to change.
Okay. And in your direct testimony, you provided a second scenario, which was just sort of a larger scale than an operator with 1,000 wells if they were required to single well bond. Can you just explain, is it the same math, or would you change it?
Yeah, same math. You're still looking at a 50% collateral. And honestly, sometimes we'll see that the larger that amount being required to bond sometimes leads to even higher collateral because, again, it's a larger amount that is being exposed. So I would anticipate that, again, it's an absolute minimum of 50% collateral that you're going to see in a scenario like this, with, again, the premiums likely being in the 2.5% to 3.5% range. Although, given the amount, it is certainly possible that that rate range is subject to change.
And when a surety company requires collateral, are you familiar with how an operator or a company satisfies that? Is it typically through a letter of credit, or is it a deposit of cash?
Yeah, it's either of the two. So typically, most sureties will provide the option for cash. Oftentimes, when you do, they'll allow you to put those into an investable fund, so it can at least grow slightly. But that cash is still tied up. Or it is a letter of credit that is going to, or drawing down a revolver with your bank or whomever your lender is, but they are tying up funds. I have not come across a surety that's willing to take into account collateral, say on wells. They're looking for the cash to offset that collateral.
So an operator couldn't rely on their portfolio or their assets as wells necessarily to satisfy any of those collateral requirements.
The best of my knowledge, that is correct. And I will give you one little asterisk there. Some underwriters will look at and take into account third-party well reserve reports when evaluating the financial comfortability that they have with any given operator. But no, they will not use that to offset collateral in the traditional surety market.
So that third-party reserve report, maybe it could be considered in the setting the premium rates, but it's not going to be available to demonstrate collateral.
Correct.
Okay. And I'm sorry to jump around, but I neglected to ask you this when we were looking at this statute. One of the forms provided for in the statute is that a well-specific plugging insurance policy pursuant to the provision of the section. And I'm going to scroll a little bit because at part F, our statute goes into some details. Are you familiar with well plugging insurance policies?
Yeah, so several years ago, a company called One Nexus was created with really an intent to provide an alternate and more effective solution to the traditional means of complying with P&A bonding requirements. One Nexus was able to successfully develop an insurance product that's able to comply with the plugging requirements mandated by regulators, but that also allows the operator to transfer some of that cost of those plugging and abandonment expenses to an insurance provider. It's got a very similar arrangement to a traditional surety bond. One Nexus uses what they call an asset retirement agreement, an ARA, as their three-party agreement between the operator. If you were on a bond, that would be viewed as the principal. One Nexus, who would be kind of deemed the guarantor, and the regulator, who in a traditional bond you'd label the obligee. Payments under that asset retirement agreement are managed by One Nexus's Oklahoma Captive Corp. It's a protected cell captive insurance company that's regulated by the Oklahoma Insurance Department, OID, and each asset retirement agreement is backed by a CLIP, contractual liability insurance policy that's issued by the captive with funds that are legally ring-fenced and reserved exclusively for decommissioning obligations. The captive's financial capacity is underwritten by a global insurance carrier called Munich Re. Munich Re is providing capital support to underwrite up to $2 billion in gross decommissioning liabilities. The part of the reason that this product is so similar to a bond itself is the CLIP, that contractual liability insurance policy, provides the same non-cancelable insurance backing that is similarly present in surety bonds. So it is an uncancelable policy. When a claim is made for a plugging expense, those claim payments are made to the principal or operator with the regulator as beneficiary, thus ensuring that the funds are used as intended. Currently working with Colorado and One Nexus to incorporate this option for Colorado-based operators as well. And actually, I think New Mexico might have met with One Nexus at one point in time, but I'm not sure if that. I'm not sure where that conversation went.
All right, thank you. So you're familiar with this One Nexus product, and did you mention that you're already in the process and working in Colorado?
Yes, ma'am. So ECMC is the group that oversees oil and gas in Colorado. We're working in partnership with ECMC and the Attorney General's office to get formal approval here. We are, seems like, very close to the finish line. We are awaiting the formal thumbs up from the AG's office, at which point in time we'll sit in a formal hearing with ECMC to see if we can get the final layer of approval to implement this here in the state.
And will that implementation be available in Colorado for all operators, or is it on kind of a one-by-one basis? Does each operator?
That is a great question. Our intent is to make it available to all. If we can get the state ultimately comfortable with the product itself, which I wholeheartedly believe if we can just continue spending time on this, they will be. It is just as broad as a bond, but it will actually transfer the risk. But our intent is certainly to make it available for all and not just some.
Okay, thank you for diving into that. And so we just talked about insurance, but I believe in your direct testimony, you explained kind of at length that bonds are not insurance. So if you could just compare the two for us today.
Sure. So unlike an insurance policy, a bond is a financial guarantee rather than a risk transfer mechanism. Okay, so a bond represents a promise to pay. It's typically backed by either cash or an irrevocable letter of credit from the operator, or by a contractual obligation from a third-party guarantor, like a surety. In contrast, insurance involves the transfer of risk. So the policyholder pays a premium to an insurance carrier, which in turn issues a policy outlining the specific terms, conditions, and coverage limits under which they'll indemnify the policyholder for covered losses subject to any deductibles. I guess the key distinction is that with insurance, the financial risk is transferred from the operator to the insurer. With a bond, the risk remains with the operator. The surety only steps in if the operator fails to meet its obligations, and even then, the operator is ultimately responsible for reimbursing that surety.
Okay. And so the insurance product, like One Nexus, there's actually a shifting of risk there to where it would cover the entire plugging and reclamation liability for the well rather than a set amount. Is that right?
Yes and no.
Okay.
So yes, that is right. It is a transfer of risk. You are spot on with that. I guess the delineation is that the insurance amount, the payable amount, is set by the operator. And typically how we envision this happening is it's in partnership between the operator and regulatory body, right? So if the regulatory agency says that, and I'm going to make up a number, you need to insure each of these wells for a penal sum of $10,000. The operator may choose to insure those wells at $10,000. They also, however, have the flexibility to, say the operator perceives their actual plugging costs are $150,000. They could insure each of those wells at $150,000 or $400,000, et cetera. So you get the ability to dictate the amount in which you want to insure them for. If you want to meet regulator compliance and use that amount, you can. If you would like to buy a larger limit of insurance, you could also do that.
Thank you for providing that clarification. You mentioned earlier, so I know you're active in Colorado. Were you also involved in the Colorado rulemaking procedure that changed their financial assurance?
Yes, ma'am.
Can you tell us a little bit about your experience and what you've seen in Colorado?
Yeah, I mean, it seems like it was a very similar situation, you know, a lot of discussions that were taking place. I can tell you from my perspective, the reform in Colorado wasn't really successful. It's, you know, in fact, I think if anything, it might have created some unintended consequences that should maybe serve as somewhat of a cautionary tale for New Mexico. You know, ECMC touted its 2022 bonding overhaul as the strongest in the nation. The reality is that the rules have increased financial pressure on operators without meaningfully reducing the orphan well problem. I think there's several key outcomes that sort of highlight the failure of that reform. The new bonding requirements have contributed to operators becoming financially unable to comply. There was an example in Colorado, a group called KT Resources, a small operator here that failed to meet its financial assurance obligations, and they received a couple dozen violation notices. As a result, 107 wells that it had acquired in 2022 are now expected to be orphaned and transferred to the state for plugging and remediation. Here, at least, the rules allow large operators to use blanket bonds and discretionary financial assurance plans, while small and mid-sized operators lack the production volumes to fund their own decommissioning, making them more vulnerable to insolvency and orphaning itself. With more wells being orphaned or potentially orphaned, the financial burden is really shifting to the state and taxpayers.
Okay, thanks. And you mentioned earlier, and I think I skipped the slide, but that the surety market is really difficult, and that is it true that it may not be available to every operator?
Yeah. So we've touched on this a little bit, but most operators are required to post collateral to secure their bonds. In my experience, the collateral requirements can be upwards of 50 to 100% of that bond amount that is being required. And it's largely dependent on the operator's financial strength and the size of the bond itself. Generally, the larger the bond, the higher the collateral requirement. In addition to the collateral, sureties do charge an annual bond premium for issuing that bond. So again, in this sector, typical premiums range between 2.5% and 3.5% of the bond amount. That is an annual premium, so it is charged on an annual basis. And the combination of substantial collateral and recurring premium costs can significantly increase the overall operating costs. Right. So for your small to mid-sized operators, absorbing these costs is often neither feasible nor sustainable, especially in your more capital constrained environments.
And so for an operator who's not either eligible or it just doesn't make financial sense to get a surety bond, what are the other forms that would be available to them?
Cash, letter of credit, and it's pretty minimal.
Okay.
I guess now you also have the One Nexus, assuming that we could get a approval as that of them as an alternate to this.
Okay, thanks. So to summarize, it would be the surety bond, a cash bond, a letter of credit, or possibly a well plugging insurance policy. Is that the four that you're thinking of?
Yes, ma'am.
And our statute provides for all four of those.
Yes, ma'am.
So that actually you ran through your direct pretty fast here. I do want to give you the chance. You submitted some rebuttal testimony in this rulemaking. And I know maybe we're beating this over the head, but does a bond insulate or insure the state in any form?
No, I would say that it does not insulate or insure the state at all. A bond is a financial guarantee. It's not a risk transfer mechanism. It does not shift financial liability or financial responsibility away from the operator. Instead, it ensures that if the operator fails to meet its obligations, such as plugging and abandoning a well, the state has a mechanism to recover those costs, either through the bond's collateral or by pursuing the surety. However, the recovery is not automatic or comprehensive. The state often engages in a claims process, which can be time-consuming and uncertain. In contrast, an insurance is designed to transfer risk from the insured to the insurer. When a cover loss occurs, the insurer is contractually obligated to pay, subject to the policy terms. Bonds don't offer that kind of protection. They are contingent liabilities, not indemnity instruments. So while a bond may provide some financial recourse, it does not insulate or insure the state against the full cost or risk of non-performance. And I think the distinction is critical when evaluating the effectiveness of bonding requirements as a tool for environmental protection and financial assurance.
Another argument that's made is that a surety market is just like any other market, just like the car insurance market. And so obviously it will respond. If there's a demand, they'll make that product available. Do you have a response to that position?
I think it's an unequivocal no. The surety market operates very differently from the traditional insurance market, and especially something like auto insurance. Sureties don't pool risk in the same way that insurers do. They underwrite each bond largely based on the financial strength and creditworthiness of a particular operator. So this means that access to bonding is selective and constrained, especially for your small and mid-sized operators or those with limited liquidity. Unlike car insurance, which is broadly available and priced on actuarial risk models, surety bonds often require significant collateral, again, sometimes up to 100% of the bond amount, and they're subject to strict underwriting criteria. If an operator doesn't meet those criteria, they could be denied bonding altogether, regardless of their operational track record. Additionally, the surety market is capacity driven. If regulatory changes dramatically increase the demand for bonding, as we've seen in Colorado, sureties may not have the appetite or bandwidth to respond quickly or at scale. That can lead to market bottlenecks, delayed approvals, and even operators being forced out of compliance due to lack of access.
Sorry. I had one more question. Just in the terms of the practical effects, the way a bond works, even if there's financial insurance posted for a well, when it comes time to plug that well, is that money available?
No. And actually, will you just repeat that again? Because I want to make sure that I answer directly what you're asking.
Yes. Okay. So if an operator posts a bond, a single well bond for a well, and that operator is then ready to plug that well, can the operator access the sums that are tied up for financial assurance?
Thank you. Yeah, absolutely not. So again, there's no transference of risk. This is singularly a promise to pay. So the surety is saying that in the event operator defaults, these funds are being held in reserve for that scenario. However, as Armstrong or whomever it is goes to plug any of their given wells, they are using existing capital for those costs. They do not have the ability to access the penal sum being guaranteed by the surety, any of the collateral that's being used to guarantee that. It is a totally separate bucket that is drawn upon.
And so if the state is the beneficiary under the bond or arrangement, can the beneficiary access those funds if the well is orphaned and it falls to them?
Yes. So in the event that a well is orphaned, the state does have the ability to go after the bucket of money that's available. So in the case of a surety bond, the state must first declare the operator in default and then initiate a formal claims process with the surety. The process can involve documentation of noncompliance, negotiation or dispute resolution, legal proceedings if the surety contests the claim. It can take months, it can take years, during which the wells, may remain unplugged. For collateral-backed bonds or letters of credit, the state may still face delays due to bank processing timelines, legal review of drawdown rights, and again, importantly, these funds are not available for the operator to perform the work themselves. So once the state steps in, the operator is typically out of the picture. The state must manage the plugging and remediation. Often, it seems at a higher cost and with limited flexibility than what operators can perform on their own. The financial assurance mechanism, it does not function like a liquid reserve. They're contingent reactive tools, not proactive funding sources.
Okay. And so I think I just lost my place. Just a second. And so one of the things that we've heard in this rulemaking proceeding is that these rules are intended to address risky wells and risky operators. Would increasing financial assurance levels accomplish that objective?
Not really. I think that just raising the financial assurance requirements doesn't automatically solve the problem of risky wells or risky operators. It's a blunt tool being used to address a nuanced issue. Higher bonding doesn't prevent risk, it just prices it. It doesn't improve well integrity, it doesn't ensure better operational practices, and it doesn't guarantee the state will be made whole if something goes wrong. In fact, if the bonding requirements are too aggressive, they can lead to more orphaning, not less, because operators who can't meet the new thresholds may walk or go under.
And have you seen that occur in Colorado following the Colorado increase to financial assurance?
Yes.
So two of Welk's witnesses, Mr. Morgan and Mr. Peltz, both proposed that those who benefit from the production of wells should pay for the decommissioning and the reclamation costs. Do you agree with that position?
I do. I think it makes sense. I think it makes the most sense for operators who benefit from the entire life of the well to share in costs associated with the decommissioning. But I don't think the proposed rules accomplish this by limiting the additional financial assurance burden to low producing wells. On the other hand, from what I understand of it, is that the New Mexico Oil and Gas Conservation Tax would do that by carving out revenue over the entire productive life of that well.
And I apologize for jumping around, but I remember the question I needed to ask you. So we've heard a lot of discussion about whether the bonds required by our statute 70-2-14 are cancelable or whether they're conditioned on the plugging of the well. Do you have an opinion? And I'll share that statute again for you. Do you have an opinion as to whether security can cancel or release a bond prior to a well being plugged?
Cannot.
Okay. Thank you. And so that concludes Mr. Gilstrap's direct and rebuttal testimony. And we have some brief rebuttal testimony to offer.
Thank you.
So Welk's expert witness, Mr. Peter Morgan, at page 6, lines 3 through 15, asserts, and also at page 8, lines 5 through 11, he asserts that the surety market will respond to the demand that's created by these regulations. Do you have the same opinion?
No. I think that the surety market is capacity driven. So a sudden surge in demand can very possibly not be met quickly or at scale. I mean, we saw this in Colorado. It sent absolute ripples through the surety market, had people scrambling to figure out what they were going to do to secure that capacity. So no.
Okay. And then Mr. Peltz, which is Exhibit 82 at page 13, he provided this table, Exhibit 84. And the note 3 states that these premium rates are based on surety premiums from the Bureau of Ocean and Energy Management. Is that would you consider that an accurate source for estimating premium rates today in New Mexico?
No, I would not. I think that they are likely wildly skewed from what we would see for onshore wells. I believe that there was a more recent study that even showed those had increased to nearly $2 million. It's just we're talking about apples and fruit flies, right? I mean, these are just two totally wildly different scenarios. So no.
Okay, thank you. And finally, what we've heard a lot, Mr. Morgan, Exhibit 81, page 26, lines 17 through page 27, line 1, that these proposed rules take a risk-based approach to address those wells at the greatest risk of orphaning using the surety company's analysis of risk. Is that your understanding of how a surety evaluates an operator before offering a bond?
No. So sureties, it's just not how they work. Because again, there's not a transference of risk. Underwriters typically within the surety world look to underwrite to a zero loss scenario, and that is largely dependent on the cash liquidity and financial stability of that company. So they're not deep diving into the operational wherewithal. I suppose maybe if you have someone that is consistently showing up in newspaper headlines, that they could be referenced maybe as part of that underwriting process. But no, it is largely driven to underwrite to a zero loss scenario that is almost exclusively driven by the underwriter's comfortability with the financial wherewithal.
Okay, and in this slide of your rebuttal demonstrative, are you familiar with the master orphan well list that the Oil Conservation Division produced in this matter?
Somewhat.
Somewhat. And then the Oil Conservation Division also produced what's labeled as Exhibit 29, which is a list of all the financial assurance that's on file with the state currently. And so is there anything you can explain to us about this slide in terms of whether a surety evaluates risk?
Yeah, so it seems like a good example to emphasize the point that they don't. 8 out of the top 10 on here who have orphaned wells in New Mexico were all able to attain surety bonds. So I think that helps to, if anything, prove the point that that's not what they're in the business of reviewing or underwriting.
Okay. The other attorneys will have questions for you as well as the commission, but this concludes our sir rebuttal testimony, and I'll proffer Mr. Gilstrap's direct and rebuttal testimony and the demonstrative sir rebuttal slides.
All right. I'll pause for a moment in the event there are objections. Oh, they're admitted. Thank you. Let's see, Ms. Fox or Mr. Tisdale? Okay.
No question. No questions. Thank you for your testimony.
Mr. Tremaine, do you have questions?
Thank you. Ms. Fox is throwing me a curveball there. All right. Good afternoon, Mr. Gilstrap. My name is Jesse Tremaine. I'm the legal director for the Oil Conservation Division. I just have a couple questions for you. On your recent slide, that you were going over with Ms. Tripp, you were talking about some of the operators on the master orphan spreadsheet and indicating that I believe you indicated that the existence or the fact that they were able to obtain financial assurance or sureties indicated that they were not assessed according to their relative risk. Is that a fair statement?
I believe that they weren't assessed based on their operational risk.
Okay. And do you have any knowledge of when the operators on that list that you showed provided or acquired their respective financial assurance?
I do not, but I can elaborate on that some if you'd like to just talk about generally what happens with the underwriting process for existing bonds.
Okay.
So typically when a bond is first put in place, there is a robust review of the financial stability of that organization. Sureties then, and different sureties vary. Some of them review those financials on a quarterly basis to ensure continued financial wherewithal. Some of them do it on an annual basis. That can fluctuate largely based on commodity price. So for example, during COVID, we saw a much higher scrutiny over those bonds because we saw such a precipitous decrease in the commodity prices. Surety underwriters were really getting more into the weeds of the finances of the companies that they were providing those bonds for. So it really does vary. Sureties do have the ability to change collateral throughout the course of that bond as well, because these are uncancelable. So for example, a surety could put a bond in place, and I'll use Armstrong because I caught the tail end of Armstrong's presentation. If Armstrong has a bond in place right now that has a 50% collateral tied to them, and for some reason they've had a slip in their financial wherewithal, the surety company, upon review of those finances, either on a quarterly, semi-annual, or annual basis, would have the ability to increase the collateral they're requiring of Armstrong.
Okay. So, Mr. Gilstrap, thank you for that. Do you have any personal knowledge of the terms or conditions of the financial assurance associated with any of those companies that you referenced?
Do not.
Okay. A couple of questions here. You know, a lot of hay is being made in this hearing, distinguishing sureties from insurance, and I think my understanding is that the real primary distinction is that sureties don't shift risk. If in the event that OCD plugs an orphan well and OCD then calls the bond on that well, and the surety pays out the bond. The reason, tell me if you agree with this, the reason you're saying that a financial assurance instrument does not shift risk is because, according to the agreement, the surety can go after the operator for that money.
Not can, but will.
Can't will. Okay. What happens when once you go after the operator, they don't have any money left?
So it's part of the reason that we see such high collateral requirements from these sureties is there's not a ton of recourse. So the surety can certainly try and sue them for the assets that they have. They will certainly take the collateral that has been made on hand, but sureties underwrites to a zero loss scenario. So when a surety is sitting here evaluating whether or not they want to provide terms to any given operator, they're going to do so if they feel comfortable that in the event this operator did default, that they surety would be able to collect 100% of the funds being promised. Does that answer your question?
It does. Thank you. You testified to the an increase in collateral, and this has come up a couple times in discussing Colorado and the proposed increase in FA. Mr. Gilstrap, why specifically have sureties increased their collateral or premium demands of operators in recent years?
So I think as penal sums continue to increase, so does the exposure for the surety. Again, a surety is not a transfer of risk. It is simply a promise to pay. And sureties, like all other companies, are in the business of making money. So as these exposures continue to increase, they look to offset their exposure as well, which is why we're continuing to see those rise.
So, Mr. Gilstrap, I'm going to paraphrase. I understood that to be insurance speak for sureties have had to pay out bonds. So you're starting to charge more for bonds. Is that right?
I think it's twofold. Sureties, yes, sureties have had paid bonds before. Absolutely. Companies have gone under. Sureties have had to pay those bonds. That's the intent of putting them in place. But again, they're not actually transferring risk. Their intent is to never have a paid and unclaimed balance of that amount paid. So as we continue to see rising penal sum requirements or bonding requirements throughout states, underwriters are looking to offset their exposure by requiring more collateral from companies to ensure that in the event of a default, they are not left out to dry.
Okay. And in your understanding, observing this trend in the insurance and surety industry, those change in terms have resulted from sureties having to pay out on a significant number of surety instruments, correct?
Again, I think it's largely due to rising requirements in this space. But I think that there's a larger exposure for these surety companies. Is the increase being driven singularly due to losses, I think is what you're asking? I don't think that's accurate. I think it's being driven due to a higher increase or exposure for losses due to rising increases to these bond amounts.
I'm not asking you if it was a singularly driven by losses. I'm asking you if losses are contributing to those changes of terms.
Very possible. Admittedly, I'm not a surety underwriter, so I don't know that I can answer that any better than I have. Sorry.
Yeah, sorry. I'll move on. Thank you. Mr. Gilstrap, you made two statements that I want to follow up on in your direct and rebuttal today. First, you indicated that the terms or that sureties will look at the financial strength and creditworthiness of individual operators. And then you made a statement that higher bonding doesn't address risk, it just prices it. So am I understanding your testimony correctly that sureties will require more collateral and or higher premiums for operators who the surety deems have less financial strength or lower creditworthiness?
Without repeating everything, we just repeat that last question, the last sentence, I'm sorry.
Would you agree that sureties require more collateral or higher premiums if they are looking at an operator that the surety deems has either less financial strength or lower creditworthiness.
Yes.
Okay. Does it not stand to reason that an operator with less financial strength and lower creditworthiness represents a greater risk of orphaning their wells?
I'm not sure that I'm the right person to respond to that. I'm just an insurance guy. I'm not an operator. But my mind goes to companies that operate stripper wells or some of those marginal wells. I think that they've got much tighter financial constraints and cash flows. And I don't know that necessarily makes them a greater risk. If anything, I think that those folks can be beneficial to the state. As you see some of the super majors looking to diverse some of those from their perception, crummier assets. I think it's great that you have companies out there that is largely their focus. And I don't know that just because their revenues are lesser than some of their peers that are drilling newer, bigger, better wells, I don't know that it makes them a worse risk in terms of their operational efficiencies.
So in that hypothetical, a surety is looking at an operator that they deem has less financial strength. And that's the reason why the surety is going to require either additional collateral or higher premiums, but you're stating that does not mean those operators are higher risk. I just want to be clear.
Yeah, I don't think that just because they don't have the same sort of margins means that they're more exposed or at risk for going under. But I think from the surety's perspective, it means that those folks, should they go under holistically, have much less access to cash flows to pay out the penal sum that is being promised. As such, they're required to put up more collateral and or potentially pay a higher premium, because in the event they go under, they might not have the same sort of cash flow as one of their larger peers with those higher revenue efficiencies.
5 minutes, Mr. Tremaine.
I think I have one more. Mr. Gilstrap, in your direct and in your rebuttal, you talk at some length about sureties, the process by which and any given surety's reluctance to pay out or potentially their opposition to that. So on your rebuttal testimony, page 3, line 7, you state, under most commercial surety or indemnity agreements underlying a bond, the surety also retains the power to negotiate or settle calls on bonds, which all sureties enforce zealously. You then state that OCD is familiar with this dynamic with over $700,000 in bonding by Kano Petro and having collected just over $161,000 4 years later. Mr. Gilstrap, are you implying that the bond payout related to Kano Petro was a negotiated sum?
I admittedly don't know definitively. My assumption is yes, it was.
Okay, if I told you it absolutely was not, would that cause you to alter your testimony at all?
Is that an opinion or is that fact? It was not a negotiated amount.
I don't get to testify, but I'm telling you, if you accepted the premise that was not a negotiated amount, would that change your testimony?
In terms of surety carriers having the ability to negotiate those final payouts, no, it would not change the testimony.
Have you looked into or been advised by any legal counsel as to the state of New Mexico's ability to negotiate?
Have not.
Bond payouts? Okay. Thank you. And just to wrap, I just want to make sure it's clear for the record. So you don't have any personal knowledge of the Kano Petro bond forfeiture or any specific forfeitures that have been pursued by the Oil Conservation Division, correct?
That is correct.
Okay. Mr. Gilstrap, thank you very much for your time. I have no further questions.
Thank you, Mr. Tremaine. Mr. Moore, do you have questions of Mr. Gilstrap?
Madam Hearing Officer, it's Ari Birnoff. No questions for Mr. Gilstrap.
Thank you. Let's see, Ms. Nanausi, I don't believe is with us. Mr. Maxwell, do you have questions?
No questions. Thank you.
Thank you. Mr. Rankin, any questions?
None from me. Thank you.
Alrighty, EOG is monitoring. Mr. Swazo, any questions?
Yes, Madam Hearing Officer, just a couple of questions. Good afternoon, Mr. Gilstrap.
Good afternoon.
I want to ask you a couple of questions about this One Nexus insurance policy that you explained to the commission. Is that the only one well plug-in insurance policy on the market that you're aware of?
It is the only one that I am aware of, correct?
And do you know what states it's available in?
I believe that it just was put in place in West Virginia. I believe I saw an article from the governor touting, I think Diversified Energy just did a deal in West Virginia. I believe it is now available in California, and I believe that One Nexus is nearing the finish line of a product for Wyoming as well. Admittedly, it's very possible they're in other states, but I do not know definitively.
So then it's safe to say that that is not available as an option in New Mexico. Is that correct?
I'm not sure that I agree with that. I don't know if it has been used in New Mexico, but based on the way that the rules are written, it looks as though New Mexico currently allows for a insurance product to meet the bonding obligations. So without being an expert on the New Mexico laws, my perception is that it would be an acceptable product to meet the existing requirements and or proposed new requirements.
Now, in these other states where you are sure that it is available, did that type of insurance policy have to obtain approval from whoever administers their insurance oversight?
I do not know the answer to that. I can tell you in Colorado, the answer is yes. And the reason being, it seems like one of the biggest differences, at least from my knowledge, between how compliance with these requirements are written is that Colorado's wording does not include an insurance policy as a viable alternative. Therefore, it's required approval from ECMC.
So then, in order for an insurance policy for the plugging of wells to be available in New Mexico, is it your understanding that it would have to be approved by, I guess, the New Mexico Superintendent of Insurance?
If it wasn't, I guess I'm not sure how to answer that. As is, I don't believe so, because based on at least the wording that I've seen, it seems to, the rules seem to already allow for an insurance product to be utilized. If the regulatory agency took the position that that wasn't the intended wording, then I'm sure it would require additional clarification. But my assumption is it would be accepted.
Okay. No further questions.
Thank you. Ms. Tripp, do you have any redirect?
No, I do not. Thank you, Mr. Gilstrap. The commissioners may have questions for you.
All right. Commissioner Mpoma, do you have questions of Mr. Gilstrap?
Yes, I do. So I'm looking at the numbers that you put up as part of your testimony, discussing, let's say, as scenario 1 and scenario 2. So with your scenario 1, you're looking at operators with 150 wells and also with the 15% threshold needs. And they are required to pay, if the premium that you are providing here, let's say 2.5 to 3.5, you know, to the high of about $787,500 per year. I mean, so I'm just still thinking about for small operators, is there any way where we can have, let's say, financial assurance that protects the states and also does not necessarily cripple these companies?
That's a great question. And honestly, I don't know that I'm in a position to help find a solution. I was brought in to comment on what was being proposed. What I will say, Commissioner, is I do think that Acceptance of a One Nexus product will help in this. It's at least a transference of risk. To be clear, though, the One Nexus, it comes with a premium as well, right? We're going to see similar premiums with an insurance product. I guess the biggest difference is that you're essentially using those premiums to pre-fund future costs, which is a huge differentiator between an insurance product and a bond, because those premiums that you're referencing, that $562,000 to $787,000, those are sunk unrecoverable costs that aren't going towards future plugging expenses. I'm sorry, that probably wasn't as direct a response as you wanted.
Yeah, so maybe this might be similar to that of the insurance that you are discussing, but don't you also believe that there could be a way where we can pass a minimum FA requirements for these wells, and then also probably something in lines of like a cost per barrel basis to build up the cost to plug the wells, where OCD can have access to that amount. So instead of a company, a small operator, putting up $150,000 per well, but they can put up some and then also more or less charge on per barrel basis to really build up the cost to that amount to plug the well, just in case that operator defaults. But if the operator plugs their well, then they have access back to their money. Can you comment on that?
I am very in favor of alternates to just singularly increasing the financial assurance obligations. I think that the idea of some sort of pre-funding pool is fantastic. Again, haven't certainly seen anything in outline to be able to comment on it specifically, but yes, I love the idea of creative options outside of singularly just increasing financial assurance levels.
So the pre-funding pool you just mentioned, has it been implemented in any other states?
I'd have to go through and look to tell you that. I'm not sure off the top of my head.
Thank you, sir, for your testimony. No further question.
Thank you.
Thank you. Commissioner Bloom, do you have questions?
Thank you, Madam Hearing Officer. Yes, good afternoon, Mr. Gilstrap. Just a couple questions. We've heard contradictory testimony during this hearing about whether bonds can be canceled if a well were to leave this, what would be a newly created marginal status. The OCD says yes, you said no, correct?
Yeah, correct. Bonds are a non-cancelable product. The only time the bond is canceled is when they are released by the regulatory body or called upon.
So if a well were to be bonded because it was marginal and then it increases its production, couldn't the state, the obligee, then release that bond?
So I guess the state could release a bond whenever they want to. My assumption is that in that particular situation, the state wouldn't release the bond. If anything, they might change the amount of the bond. So if there's a higher amount required for a marginal well than there is a high producing well, presumably it would be a stair step down in the bond requirement, but not a release thereof, because it's still a well that has at some point in time, end of life expected and will need to be reclaimed.
Okay, thank you. I mean, this is but I think an essential matter here, because one of the things that this proposed rulemaking would do is really push operators to either plug their wells or increase their production so that they don't have to be bonded, so they don't go into marginal status, so they come out of marginal status. And we have a disagreement among the parties as to whether bonds are cancelable or if there's a way to drop a bond on a well that was once marginal. I'm not quite sure how we're going to work this out. Anything else you can add?
I can tell you that plugging and abandonment bonds are non-cancelable. It's part of the reason that you see such high collateral and premium requirements tied to them, and such scrutiny over the financial liquidity of that particular operator, because once put in place, the surety cannot cancel that bond. The only way they're getting off that bond is if released by the regulatory agency that's requiring the bond.
Yes. Okay. In response to your question from Namoga, you mentioned diversified energy, which in some ways, I don't know if it's instructive or not, but that's a company that has 20,000 wells across, I'm thinking like West Virginia, Kentucky, Pennsylvania, Ohio, that area. 20,000 wells and 2,600 of them are considered abandoned. I think originally they were going to plug P&A, 580 of those over the next 9 or 10 years. And now they've agreed to do 5 times more, about 2,600 wells. Any takeaways from that?
I think that the biggest takeaway, I guess, would be that regulators in the state of West Virginia resonated with the One Nexus product and found it as a viable tool to help insulate them and taxpayers from that exposure. And so they gave it the thumbs up and felt that, and again, this is opinion, I obviously don't know definitively, but felt that it was a better tool to help insulate them from that exposure as opposed to traditional surety.
Okay. Mr. Gilstrap, thank you so much for your time. No further questions.
Thank you.
Thank you. Chair Chang, do you have questions?
Sure, just a couple. Is it your understanding, Mr. Gilstrap, that sureties are a more common and preferred financial assurance instruments in the oil and gas context than insurance policies?
I would say common definitively, but I think that's largely driven by the fact that an insurance product to potentially displace the need for a bond hasn't existed until recently.
I see. Okay. I was going to ask, because a follow-up question I had was whether you could help me understand why insurance policies aren't as popular or may not be popular, but sounds like it's just not been on the market for as long.
Yeah, and yes.
Okay. That's all I had. Thank you.
All right. Thank you, Mr. Chair. Any reason not to excuse Mr. Gilstrap? Thank you very much, Mr. Gilstrap, for your testimony.
Thank you.
Madam Hearing Officer, I believe Mr. Cloutier will be calling our next witness.
Thank you, Ms. Tripp.
IPA&M calls Calder Ezzell to the stand. And for housekeeping purposes, Madam Hearing Officer, I think it's very likely that his direct rebuttal and surrebuttal will take longer than the hour we have until public comments. So if you want to flag for me where a decent stopping point is, I'll try and wrap up a topic before public comment.
Too disruptive to ask that you find a breaking point around 3:30, 3:40, somewhere in there.
No, I'll look for one. Thank you.
Thank you. Mr. Ezzell, would you spell your first and last name, please, for the transcript?
Calder, C-A-L-D-E-R, Ezzell, E-Z-Z-E-L-L.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Cloutier.
Would you please introduce yourself to the commission?
My name is Calder Ezzell. I'm an attorney with the Hinkle Shaner firm in Roswell, New Mexico.
Move to slide 2, please, Mr. Everhart. If you'd describe your legal background in a little more detail, please, Mr. Ezzell.
Well, I went to undergraduate and law school at Washington and Lee University in Lexington, Virginia. Graduated with my JD in 1977 and joined the Hinkle firm that summer and have hung on this long. I'm a transactional lawyer. I do title opinions, JOAs, farm outs, contract negotiations. I did have an OCD practice years ago. But that was before the firm had a Santa Fe office. And once we opened a Santa Fe office, we transitioned that work up here because it wasn't economical for them to pay me to drive to Santa Fe. So, and I miss it. I really like my OCD practice.
And all of the transactions that you described, those are oil and gas industry specific, Mr. Ezzell?
Yeah, you can throw in 2 or 3 solar contracts and things like that for, I'm also a rancher, and I have lots of ranching friends that have need for free attorneys a lot.
Yes, sir. I seem to remember an auto mechanic too one time, but
that's true too.
We won't bring up firm management issues here in the commission. Would you describe to the commission your background in the oil and gas industry in addition to what you've described in your legal career?
Well, I have been an individual non-op investor in oil and gas wells for over 40 years. As a result of one of those investments, or actually a couple, an operator who was a friend of mine and a client got in over his head because he also had a trucking company and a drilling company, and that didn't work out very well in the early 80s. And when he was forced into bankruptcy and resigned as operator of all the wells his company had, I was in 3 of those wells. And so I assumed operations in a company called Polo Oil and Gas. And I operated those wells, operated in air quotes. I didn't do any of the field work. All of the physical stuff was done by 2 of the former operator's employees. One was his geologist and one was his engineer. And so they took care of all the field stuff. And I got bonded and sent out the bills and paid the checks, wrote the checks, and kept those 3 little wells going until my friends, the geologist and engineer, got enough backing to where they could start their own company. Then I turned the operations back over to them. And I take it back. I did get frisky once as an operator and tried a re-entry, which was an abysmal failure. And I was advised never to name an oil well after your dog.
Thank you, Mr. Ezzell. You submitted direct and rebuttal testimony to the commission in these proceedings, correct?
Yes.
Okay. Any changes or corrections? And if you could pull the mic a little closer to you, I don't mind you leaning back, but you're just a little bit.
I am embarrassed to say that I have corrections. On my direct testimony, page 11, line 23, the first word of should be or. Page 13, line 21, out in the middle, the word reservation should be resignation. I don't know how that happened. Page 28, second word in line 18 should be joint account instead of direct account. This one's a little more material. Page 29, line 6. I am of the opinion that the operator can, the word not was omitted. So I am of the opinion that the operator cannot charge for that bond. Page 30, line 10. second to last word is pass, and it should be post. I can't imagine how painful it would be to pass a cash bond. Page 54, line 15, the word negotiating should be negotiated, past tense. Page 57, line 2, third to last word, payor should be prior. Now to the big one. In my rebuttal testimony, page 4, line 6, incorrectly quotes the statute by saying that the $50,000 bond amount was the maximum when in fact it is the minimum. And I do not know, so the words not to exceed should be greater than. I do not know how that happened. I wish I had an associate or a paralegal or chat GTP to blame, but I don't. So since I'm under oath, that one's on me. I do not know how I missed that mistake. So that would mean that page 7, line 19, sixth word highest should be base. Conversely, on the next page 8, in 6 and 12, the word maximum should be minimum. End of mea culpa. And except for the fact that I appreciate having been advised of that prior to getting in this chair. So for whoever did that, my faith in trial lawyers is partially restored.
Thank you. You still have to live with me. Any other changes or corrections that you wish to make? I'm not suggesting you should. I just want to
Not
make sure we're
unless I
done.
see one on a slide.
All right, thank you. Madam Hearing Officer, with those changes, we offer the direct and rebuttal testimony of Mr. Ezzell, the slides, and I'm sorry, I had the exhibit numbers pulled up, and that Mr. Ezzell is sponsoring and then closed out of them. So here we go. It'll be just a second. Mr. Ezzell is sponsoring IPA&M exhibit numbers 14 through 19, 20 through 26, and 41.
Pause for a moment in the event there are objections.
We do object, or at least want to bring the commission's attention to the fact that the analysis based upon the statute that doesn't exist that Mr. Ezzell spoke of, that entire line of analysis that follows that is based upon that reading of the statute. And so he pointed out a couple of words, but we object to really all that testimony is extremely misleading and fails to accurately cite the statute that he claims to be analyzing.
Madam Hearing Officer, that's fair enough. So why don't I ask Mr. Ezzell how the changes would affect his analysis, and I'll reoffer after Mr. Ezzell testifies. Could you explain to the commission how it changes your analysis in the rebuttal testimony, Mr. Ezzell?
Well, given the changes of maximum to minimum and highest to base, it does not change my analysis at all. It is the fact that you would have a $150,000 bond as opposed to a bond and some amount greater than 50,000 for a well that at least the applicants say is much more likely to be a problem or an orphan doesn't make sense. Well, we're going to talk about the commission's authority later, but the statute is what the statute is, and it's been corrected. And we're going from the actual language of the statute.
So, Madam Hearing Officer, I reoffer Mr. Ezzell's direct and rebuttal testimony, the demonstrative exhibits supporting that and his surrebuttal, IPA and exhibits 14 through 19, 20 through 26, and 41.
All right. Mr. Hall, I'm going to invite you to offer your arguments in the closing argument.
Thank you, Madam Hearing Officer.
Are there other objections? No, they're admitted.
Thank you. Could you move to slide 3? We have some slides about the commission's hearing authority. How would you like to handle your testimony on that authority, Mr. Ezzell? And this is your testimony, I would say, but you tell me, what would you like to do with slides 3 through 9?
Well, I can't tell what. Let's go ahead and talk about it.
All right, go ahead. We'll talk about them briefly. Go ahead, Mr. Everhart. So slide 4, any testimony for the commission?
Oh, they're enumerated. Okay. I didn't see a number on the big part of the screen.
When I ask you a question about the slide number, I've already verified that Mr. Everhart has the right slide up. So.
Oh, okay. Just the quoted language is the quoted language. The Oil Conservation Commission is a creature of statute and expressly defined, limited, and empowered by the laws creating it. And that's been recognized by the New Mexico Supreme Court in the Continental case.
All right.
Cited there.
Thank you. And next slide, please. So we've spoken about this power at some length, and I think let me ask you this question before we get to this. Have you listened in on these proceedings, Mr. Ezzell?
Not in their entirety, but often.
All right. And we've had some legal argument and testimony about this. And if I could, I'd like to spare the commission more testimony about it. So if you see something on one of these slides that you don't think the commission has heard, or you don't know that the commission has heard, please call it to the commission's attention. And otherwise we can just move to the next slide.
I would point out, and I apologize if this has been already discussed, but a lot of the legal arguments have been, is there express language in 70-2-14 that grants the commission the authority to do this? And there's been arguments back and forth. I know, and this kind of backdoor, but 70-2-14G deals with operators who magically have one of those illusory insurance policies. And it says, and it's a single well bond, in the event the one well financial assurance requirement is increased, either because the well is deepened or because the rules of the OCD are amended, then it provides what they need to do with their insurance policy. And that tells me two things. One, that the depth of a well is paramount in considering its cost. because you can't increase the bond unless you do what? Deepen the well. And then the OCD can come increase the bond. The other thing it tells me is that the OCD's ability to increase a bond is limited to the single well bond. Because that -G makes reference to it, and there is no reference made to increasing any other bond.
Good.
I would also argue that reference, I think everybody's already argued this, that the statutory maximum on the blanket bond would be the maximum on any single bond as well. And I hope that hasn't been brought out before.
Thanks. That's perfect. And why don't we go ahead and skip to slide 10, Mr. Everhart? All right. Your next area of opinions that you'd like to talk about is what?
Waste.
Okay. And what is waste?
Oh. The prevention of waste is why we have the commission. And this is statutory again. Waste includes underground waste, which occurs when operating or producing, whoops.
Sorry about that. I just realized I skipped slide 9. So what was the point you wanted to make to the commission on slide 9? And that's my fault.
Well, and again, the Continental Oil case says that the prevention of waste is the paramount power of the OCC because the protection of correlative rights is such an integral part of the prevention of waste.
Okay, and now we'll cease pulling the rug out from under you, Mr. Ezzell, and put up slide 10 again. And you were discussing waste with the commission.
And as the quoted language says, that's what constitutes underground waste. Operating or producing of any well or wells in a manner to reduce or tend to reduce the total quantity of crude petroleum, oil, or natural gas ultimately recovered from any pool. What the applicant's proposed amendments do is exactly the opposite of the commission's mandate. It, by their own definitions, will promote waste.
Do you have an opinion as to whether there's a legally permissible amount of waste that the commission is allowed to permit under its rulemaking authority?
0.
Thank you. Next slide.
I mean, I know there was a lot of testimony that, given this set of wells or that set of wells, it's going to be less than 3% or 0.2% or whatever of the state's production. But that's not the issue. The issue is the prevention of waste. The other issue, in my opinion, is that 3% or less than 2% or whatever it is could also be 100% of the business of many of our small businesses.
Thank you, Mr. Ezzell. And you're looking at the next slide. Would you explain to the commission, based on your legal and industry experience, how the adoption of the proposed rulemaking would affect the protection of waste?
Well, I think Mr. Armstrong covered that pretty well, but if you just only have one well and it's making 3 barrels a day, you're feeding your family and probably making a living, and $150,000 bond will make you sell it, plug it, or walk away from it. And anytime that there is recoverable oil left in the ground, that constitutes waste. Or gas.
And how does the rulemaking, in your view, affect correlative rights and the protection thereof?
Well, the premature plugging of wells will affect the correlative rights of all of the owners and working interest owners and royalty interest owners of the wells that are prematurely abandoned.
And that takes me back to my old OCD practice days where the last question we would ask our expert is, in your opinion, does the application protect correlative rights, avoid the issue of waste, and avoid the drilling of unnecessary wells? And that was in the OCD Bible back then. And because one of the main purposes of the OCD to protect correlative rights was to prevent the economic waste caused by drilling of unnecessary wells. That's where we ended up getting pooling agreements, communitization agreements, units, because that gave all of the owners an equal opportunity to produce their resource. Thank you. Move to the next slide, please. The next area of your testimony, would you just give the headline to the commission? Large-scale single well bonding does not work with standard industry contracts. And have you detected the sort of an underlying assumption in some of the testimony about operators that you've been hearing in this proceeding that? Yeah, everybody assumes that the operator owns 100% of the well. I think Mr. Armstrong made it clear earlier this afternoon that is rarely the case, especially with members of the Independent Petroleum Association in New Mexico. How much can an operator own in a well? Can own it all. And how little? Anything above zero.
And why do you think this assumption is important?
Well,
or challenging this assumption?
Having been an investor in oil and gas projects being proposed by small independents in southeastern New Mexico, the standard deal that you would see 40 years ago was a geologist had an idea. He sold his idea to somebody that could operate it. The operator hit the street to either existing partners or new partners. New partners were affectionately called shoe clerks, because I was one. And the deal would be on a third for a quarter basis, meaning the investors would pay all of the costs and the operator would be carried for a 25% interest. So if I took a third interest, then the operator would get a quarter. And so that's how most of these wells, and when we're talking about older wells, that's how I'm sure a large number of them were drilled. And so those operators would never have had as much as half.
Thank you. And because the commission and people in this room may not be so familiar with the term carried or carried to the tanks, how long would the investors carry the operator in a typical deal?
Until payout of whatever event was in the agreement that was made before going into it. Okay. And the two most likely would be carried through the tanks. That means the operator never put a dime of his own money into it until the well was completed and producing into the newly acquired tank. The other one would be the carry interest would go until the casing point election. The casing point election is a creature of a joint operating agreement, which is we'll get to those later.
Yep.
But at any rate, when a well is drilled to the casing point, then a joint operating agreement makes the operator notify all of the non-ops that total depth has been reached and he is electing to run casing and make a completion attempt.
And each of the non-operators has the ability at that point to say, nope, I don't want to do it. I don't like the looks of the logs, whatever. And they don't have to participate in those costs. Then it gets a little more complicated. If somebody doesn't want to do that, then his interest gets spread to everybody else. Unless somebody else doesn't want it, then it tumbles down. At any rate, then the well gets completed.
So if we can move to the next slide, what are the what are the form contracts or agreements that you wanted to describe to the commission?
Well, the most common one is the one we just mentioned, and that would be a joint operating agreement. When I first came to work, most of the older wells in New Mexico had been drilled under a form that was developed after years and years of production. But the American Association of Petroleum Landmen realized that every state had their own quote unquote standard kind of deal. And they thought it would be a good idea to bring uniformity to it. And so they came up with a form joint operating agreement in 1956. And that was very prominently used in New Mexico until later.
And we'll get to the developments of that in a minute, but that is the, on this slide, the AAPL form 610 operating agreement form.
Yes. 610 has been left. Yeah, but yes, there it is.
Yep. And then I believe next you want to testify about a common attachment to that form. What that
once there was a joint operating agreement in place, in order to compensate the operator for the costs that he would incur, there was an agreed upon overhead rate. And years ago, it was common to see a $5,000 per month drilling overhead rate and a $500 a month producing overhead rate. And that overhead charge would be what was supposed to cover the operator's costs in getting the well drilled and going. Obviously, it used to be on shallow wells in southeast New Mexico, you could almost bet on 500 and 5,000 for the overhead rates.
And where is this overhead rate found in the contracts between the operators and the non-operators?
It is found in an agreement called a COPAS, the COPAS, which is the Council on Petroleum, COP, accounting societies. And
let's go to the next slide. And the COPAS form, where would you find a COPAS form agreement between the parties typically?
It'd be attached as Exhibit B or C to the JOA.
Okay. So you had mentioned the 56 form agreement and the evolution thereof. Can you expand on that for the commission?
Well, as technology improved and people had better ideas, the AAPL ended up revising its Form JOA several times. The 1956, 1977, there's a typo. 1981 should be a 1982, 1989, and then a couple in 2016. I don't really know that we need to spend a lot of time on any of them except maybe the 56 and the 77, because all of the wells that we're talking about, in my opinion, will have been drilled long before the publication of these other these other JOAs.
And tell the commission if once a new JOA form came out from the American Association of Petroleum Landmen, would you expect that no more joint operating agreements would be used under the old form and the
No,
new form would be
you'd
adopted?
use the old form until you ran out of copies. So you wouldn't have to buy any of the new ones. The forms provided, I mean, if there was something specific to a particular operator, he'd just plug it in even by hand in Article 15, which is other provisions. And so if there was something somebody didn't like about a 77 form, they'd just fix it themselves.
Good. Let's cover the evolution of the COPUS forms and then on this slide, and then let the hearing officer know that we're ready for a break if she is.
Okay. As with the JOAs, the COPUS, the accounting people kept improving theirs, 62, 72, 84, 95, 2005, and then a new one in 2021. They are better marketers of their product than the AAPL. So when they came out with a subsequent COPUS form, they stopped selling the earlier ones and they would force people to buy the new ones.
Okay. And is there a form or draft that you would expect to see more commonly in New Mexico of the COPUS in vertical well production? That
Again, I would say the 74 form would be the most, in my experience, the most commonly used COPUS.
Okay. Thank you. Madam Hearing Officer, we're at a breaking point. It's 3:35 according to my computer. So
Great. Thank you so much. Let's come back at 10:04 and then we'll take public comment.
all right.
This is Amelia Cardania, interpreter. I'm doing a mic check. Please let me know if you can hear the interpreter. Thank you.
Let's come back from the break, please. Mr. Cloutier, if you would lead Mr. Ezzell through approximately another 10 minutes.
Thank you, Madam Hearing Officer. Happy to do so. We're still on the same slide, Mr. Ezzell. On the COPUS agreement, which do you find to be most common in vertical wells in New Mexico in your experience, and explain to the commission why that is?
I would say the 1974 form, as I stated, because of the age. It's also getting to the point where people started using computers, and they would put the form on their computer and not have to buy anymore, and that would and then they could incorporate all of that company's little pet changes in Article 15. There was actually years ago a famous story about an operator that got good enough with their computer that they actually changed the wording of the forms, but did it in the same size font and with the same type to lead their non-ops into thinking that it was just the printed form. But I'm sure that's just apocryphal.
Other than that particular change, would you see changes to these types of forms, and how would they be done?
By negotiation.
Right. All right.
Anything from take it or leave it if you want to be in this well, or between two larger companies that are working on a joint development and sharing operating, you operate the east half, I'll operate the west half, and we'll do it on the same form.
I know we can't be absolute, but you're going to testify to the commission about certain provisions under each of these forms. Would it be common to see material changes in the provisions that we're going to be talking with the commission about?
Some yes and some no.
Okay, good. If you'd highlight those when you could. Moving to the next slide, please. How does the plugging and abandonment of a well work under a standard form joint operating agreement? And I know I'm inviting a lengthy answer, but please explain.
There are two principal ways. One, it's abandonment of a well that is not produced, and the other is abandonment of one that has produced.
Why don't we focus on one that has produced here for our purposes, since I don't think non-production ever is particularly relevant to this proceeding.
On a well that is produced, as I think I said earlier, it cannot be plugged without the consent of 100% of the parties. A 1%er can say, no, I don't want to plug it, and then they will be required to take over operations.
Assuming everybody does consent, what is the operator typically allowed to do with respect to the costs of plugging and abandonment with the non-operators?
There is a provision in the JOA that puts a limitation on the operator's right to spend joint account money with a dollar amount. And so if the plugging operation is going to exceed that, technically the operator would have to circulate an AFE showing the costs of the plugging job and have all of his non-ops, the consenting non-ops to the plugging, sign off on it. Then he could bill them in advance, or he could bill them as the plugging was happening, or he could bill them 30 days later.
Okay. And I think we've heard it once in the term AFE once in this proceeding. I'm not sure it was clearly defined. What
authorization for expenditure.
All right. What is your opinion as to an operator's ability to bill the non-ops under the plugging and abandonment provisions of the joint operating agreement for a bond to cover the cost of plugging and abandoning a well?
There is absolutely no precedent for it.
All right. Traditionally, as a working interest investor in oil and gas wells, how have you seen the cost of bonding handled in billings to you as a non-operating working interest owner, as you're referring to it, a non-op?
I have never seen any bond cost passed on to me.
Next slide. What are your opinion about an operator's ability to charge for single well bonding to its non-ops under the standard form COPUS Exhibit Bs or Cs to operating agreements?
I do not think they can.
Okay.
Fixed overhead, we touched on it earlier. Fixed overhead basically is what is the income that the operator is going to get to conduct his business. And so that's why operators like to have lots of wells, because they generate an income stream that will hopefully help pay staff and office rent and things like that. The only things you get to bill under the standard forms are direct expenses for the operations conducted under the agreement.
And I believe in your direct testimony that you testified that, well, strike that. Are you aware of any case law or other legal authority that would support the idea that single well bonding could be billed to non-operating working interest owners under a JOA or COPUS agreement?
No, the only thing I could possibly think of would be a dispute that arose over someone's attempted attempt to add it to the agreement. But as far as the printed forms are concerned, it's just never been an issue.
Okay. Next slide, please. So what would you explain to the purpose of the commission, the reasons for testifying to the commission about these standard forms of oil and gas agreements, the JOA forms and the COPUS forms?
Well, it's because that's what governs the operations of all these wells that this proposed rulemaking will affect. Everybody agrees that the cost of bonding, if this rule is adopted, will increase dramatically. And the question is, who's going to pay it?
Objection. That mischaracterizes the evidence. Not everyone agrees it will increase it dramatically.
My bad.
All right. Mr. Cloutier.
Let's, without adjectives or adverbs, Mr. Ezzell, would you explain to the commission the purpose of your testimony?
As we touched on earlier, there seems to, it's just one size doesn't fit all. There are operators that will not operate unless they have 75, 80, a huge percentage of the well. There are operators that operate with much less. If it in fact is under the COPUS agreement to be a cost of doing business that you are bonded, then operators that have lower working interests in the well will be incentivized to prematurely abandon or to resign as operator. And then the resignation of operator, that's governed under the JOAs. And under the standard language there, the operator could resign without permission from anybody. The non-ops have to select another operator. But if they don't, they can require, not ask, but require that the resigned operator stay on and conduct the operations. So if that well in that hypothetical becomes subject to a $150,000 bond, who's going to pay it? The operator that's not the operator, but is being forced to act as the operator? I don't have an answer for that.
Madam Hearing Officer, I believe we're at public comment time, and so a good place to stop.
Thank you so much, Mr. Cloutier. I don't see anyone in the room, Mr. Ezzell, so you can stay where you are. I believe all of our commenters are on the platform. This is a comment period in which we have an interpreter. Amelia, if you would unmute yourself and say something about your ability to provide interpretation for this comment period in Spanish, please.
Yes, hearing officer, can everybody hear me okay?
Yes, thank you.
Perfect. My name is Amelia Cardeña. I'm a Spanish interpreter, and I will be available to interpret for anybody who wants to provide their comment in Spanish. Me llamo Amelia Cardeña, soy su intérprete al español. Si alguien quien va a dar su comentario en español desea darlo en español, estoy disponible para interpretar su comentario. Por favor, avísenos.
Thank you very much, Ms. Cardeña. All right, let's see. Sheila has pulled up Mark Nonenkamp. There are just a few things about public comment. I will ask you to spell your first and last name for the transcript. I will ask you to swear or affirm to tell the truth pursuant to the commission's requirement, and I'll ask you to keep your comments to 3 minutes. In the event you have more to say, please submit those comments in writing to Sheila Apodaca, the commission administrator. So, Mr. Nonenkamp, can you unmute yourself? Hello? It appears you're unmuted.
Okay. Yeah, my name is Mark Nonenkamp. That's M-A-R-C, first name. Last name is Nonenkamp.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead. I'll start your time.
Okay. Hello, my name is Mark Nonenkamp. I've lived in New Mexico for 23 years. I have an undergraduate degree from the University of California at Berkeley and a master's degree in business administration from the College of William and Mary in Virginia. I'm retired from the state of New Mexico, where I worked for 20 years, the majority of which was with the Tax and Revenue Department, Audit and Compliance Division. First worked with oil and gas compliance, and then with the Federal Royalty Audit Bureau as an auditor. I know that a financially strong oil and gas industry is very important to the state of New Mexico, as it provides such a major portion of our government's revenue, which in turn flows down to local governments on the county and city level, funding education, healthcare, fire departments, police departments, and public libraries. New Mexico is a relatively less affluent state with a smaller population, and a strong local oil and gas industry also provides many good paying jobs, which in turn supports the local economy and our tax base. The success of the oil and gas industry contributes to the success of New Mexico. I thank you for all of your hard work in state government in helping to make New Mexico work and function well for all New Mexicans. I hope that the agencies of state government do not impose regulations on the industry which will in any way diminish what the industry has provided and continues to provide to the state of New Mexico and all of its stakeholders. I encourage you to continue to help keep the oil and gas industry strong in New Mexico so that it will continue to benefit all New Mexicans. And I do thank you for your time.
Thank you, Mr. Nonnenkamp. We'll move next to Aria Kasberg. Ms. Kasberg, if you would unmute yourself.
I am unmuted.
Hello. Would you spell your first and last name for the transcript, please?
Yes, it's Aurea and then Kasberg, Kasberg.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Good afternoon, Commissioners. My name is Aria Kasberg, and I serve as the Deputy Energy Team Director at Earthworks, where I oversee our team of field advocates and certified thermographers across the country who document oil and gas pollution using optical gas imaging technology. Since I joined Earthworks in 2022, I've been on field trips to the New Mexico Permian Basin and to the Four Corners region to document otherwise invisible pollutants coming from the oil fields. Each visit leaves me deeply unsettled. You don't just see the problem, you smell it, you feel it. The air burns your nose, the gas clings to your clothes, and the headaches hit within minutes. I wish I could give you those headaches just for a moment so you'd understand what residents near these declining oil fields live with every day. Our field team sees this in every oil producing region of the country, aging wells, leaking tanks, neglected sites, but it's especially severe here in New Mexico, where tens of thousands of wells are nearing the end of their productive life. Many of them have little or no financial assurance for cleanup. This isn't just a New Mexico problem, but New Mexico has an opportunity to lead on this issue. The state can show what responsible, modern oil and gas regulation looks like by requiring companies to post realistic cleanup bonds before they drill. This isn't radical, it's common sense. Right now, the system doesn't come close to covering the true cost of plugging and restoring wells, which means the burden falls to the taxpayers and communities already living with pollution. We need holistic solutions that reflect the full life cycle of oil and gas, from drilling to cleanup, and that protect people, water, and air along with it. When I return to the Permian in 2026, I hope to see a region where companies are finally held accountable for the mess they've made. Thank you for your time and your considering these critical rule updates.
Thank you, Ms. Kasberg. Next, we'll hear from Catherine Harris. Ms. Harris, can you unmute yourself?
Yes, Catherine.
Hello.
Hi. Catherine, Catherine, Harris, Harris.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your time.
Thank you for allowing me the time to speak before the New Mexico Oil Conservation Committee today. My name is Catherine Harris, and I have lived in New Mexico for over 65 years. Excuse me. My husband and I have raised our family here in San Juan County, where we built our lives and contributed to our community. My husband has worked in the oil and gas industry for more than 50 years. We also have family members who continue to live and work in this area, and like so many others in this area, are directly tied to and rely on the energy industry. Oil and gas has long been the backbone for New Mexico economy. The state receives over 35 to 40% of its revenue direct from the industry and additional revenue from adjacent businesses that support the oil and gas industry. So that takes the revenue over 50%. These funds are essential to New Mexico public services, such as education, healthcare, emergency response systems, streets and roads, etc. Our schools in particular rely heavily on this funding. As a lifetime New Mexican and a grandmother who care deeply about the future of our children, I am concerned about what reducing revenue by imposing more restrictive policies and imposing more regulation, what that would mean to our schools and our community. The oil and gas industry has not only provided jobs and opportunity, but also helped support the very system that makes our state thrive. As you consider future energy policies, I urge you not to impose more restrictions and regulation, but remember the families and schools and the community who depend on the stability of this industry. Again, thank you for your time and for listening to me, a voice from San Juan County.
Thank you very much, Ms. Harris.
Thank you.
Let's see, is this Nancy Martinez? Nancy? Can you unmute yourself? The only Nancy I had to sign up. Let's see, is that you, Ms. Martinez? Hello.
I'm here. Let's see if I can get my camera on.
All right.
Okay, there I am. So
Great.
my name is Nancy Martinez. It's NancyMartinez.
Thank you. Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Thank you. Good afternoon. I live with my husband in Farmington, San Juan County. Years ago, my father, Merle Williams, who was a World War II veteran and was at Pearl Harbor the morning that it was bombed, moved back to Abilene, Texas after the war, and he began working in the oil and gas industry. In 1956, when I was 5 years old, he brought his growing family of 7 children to Farmington during the New Mexico oil and gas boom. His employment provided a lucrative job with a good living wage, enabling him to provide a home and all the necessities of raising his large family. In time, I married my husband, Larry Martinez, who began his career in the oil and gas industry at the age of 18. His employment in the exploration of oil and gas took him all over the United States and 2 different countries. But his home and his home base was always here in Farmington. We raised our 8 children here. We bought our home here. We sent our children to school here, supported our community, and paid our taxes here. He retired after 50 years in the oil and gas industry at the age of 70. We have seen firsthand how much the oil and gas industry in New Mexico provides for our families here in this state. It provides employment with livable wages and economic security for our community. It supports our educational system through tax dollars. Farmington has a community college that we've witnessed grow over the years, San Juan College, and many of the oil and gas companies in our region have provided grants to our area students who are either not able to afford to go away to college or don't desire to leave their families in this area. It also has provided jobs for the outlying reservations, the Navajo Reservation, the Ute Reservation, the Apache Reservation. These people have worked in the oil and gas industry alongside of us. These companies have also donated their time and dollars to our nonprofit organizations such as Child Haven and the Boys and Girls Club, both organizations who provide resources for the families and children in our community. Last year, I had to travel 6.5 hours away to Colorado Springs for medical procedure that 2 years ago I could have had done here in Farmington. We're losing our medical personnel in this area. The tax dollars from this industry go to support Medicare and Medicaid. Recently, a law passed providing for childcare in the state. The funds from our oil and gas industry are contributing to this. If these new regulations pass, where will New Mexico and our families be? How will we survive without the funds from this industry? We need a stronger, not weaker oil and gas industry going forward, not only for the local families here in Farmington, but for our whole state. I am urgently asking this commission to consider these issues, the economy and the welfare of the people of the state of New Mexico. I truly appreciate your attention to these details and for listening to me this afternoon and the attention that you give to these concerns. Thank you.
Thank you, Ms. Martinez. Let's see, Dudley Jones.
Yes, I'm here.
Hello. Would you
Hello.
spell your first and last name, please?
First name Dudley, D-U-D-L-E-Y. Last name Jones, J-O-N-E-S.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Good afternoon, commissioners. Thank you for taking the time to listen to our comments today. As I said, my name is Dudley Jones. I am a 35-year resident of Carlsbad, New Mexico. While I've lived here, I've had the privilege of working in various industries during my time. From 2008 to 2014, I was the manager of the Carlsbad Irrigation District, one of the senior surface water right holders on the Pecos River. During that time, we as a district were highly aware and seriously concerned with the safety and timely mitigation of the brine well located near the South Y in Carlsbad and very near our main canal, which provided water to the majority of the district. As things often go when dealing with corporations, corporate responsibility often evaporates in a crisis, and the state is left to clean it up and to pay the bill, which in this case was millions of dollars. Fact is, what you don't know can hurt you, and it'll cost a lot of money to remedy. Situations such as this are far too common in the oil and gas industry, and that is why I believe it is prudent to hold the industry accountable. It is unjust to allow state and local resources to be put at risk so that the oil and gas industry can profit. They are stockholders in a corporation with the primary goal of making money. But the citizens of the state of New Mexico are the stakeholders. We are the ones left holding the bag after the corporation has already left town with their money. This is why we need your help to represent us, the citizens, the real stakeholders of New Mexico. I want to go on record in support of the increased bonding requirements, which really, in the cost of doing business for the oil industry, is a very small portion in spite of what you may hear from other testimony. Current and future generations of New Mexicans deserve to have the environment that is preserved and protected for them. Thank you again for your time and attention to this critical matter.
Thank you, Mr. Jones. Next, Sandra Jones. Can you unmute yourself, Ms. Jones?
Yes,
Hello.
I believe I'm unmuted.
Great, thank you. Would you spell your first and last name for the transcript?
Yes, first name Sandra, Sandra. Last name Jones, Jones.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Thank you. Good afternoon. My name is Sandra Jones, and I'm speaking in strong support of the proposed bonding rule changes. I grew up in Carlsbad, and I've lived here almost 55 years. I am a retired employee of the Waste Isolation Pilot Program. As a lifelong resident of Southeast New Mexico, I've seen the changes in the environment and air quality with increased oil and gas drilling. Also, I was living here when the brine well sinkhole in Carlsbad had to be remediated at taxpayer expense because the business owner at the site went bankrupt and state and taxpayers were left paying the bill. The current bond of $250,000 required of oil and gas companies to clean up and plug abandoned wells does not come close to the actual cost of cleanup, which was found by the Legislative Finance Committee to average $163,000 per well, with some costing up to $700,000. This leaves the public to pay for plugging wells to prevent them from releasing toxins into the air and water. These proposed rule updates are an opportunity to ensure that the corporations profiting from New Mexico lands are also fully responsible for plugging their wells. If bonding is not set high enough now, there may not be enough money left for cleanup at the end of the boom. Please vote to adopt stronger bonding rules. Thank you for your time and for the opportunity to express my concerns.
Thank you very much, Ms. Jones. Is there anyone else on the platform who would like to offer comment during this comment session. We will have another one tomorrow morning at 9 a.m. If you have dialed in using your telephone, you can raise your hand by pressing *5. Anyone at all? All right, thank you. Let's return to the technical case. Mr. Cloutier, by my count, you're 43 minutes into the hour.
Thank you, Madam Hearing Officer. Moving to the next area, what's the next area that you wish to talk to the commission about? Okay. We're going to skip your microphone on there, the middle button.
The green light went away.
We've gotten some clarity on an issue that you testified regarding, so we'll skip the next 2 slides, please, Mr. Everhart. And yep, next one. Okay, and next one. All right. You've got a number of areas you want to talk about the definition. This slide, I believe, gives the headlines. So if we can move to the next slide and start talking about your first topic, which is Mr. Ezzell.
Secondary recovery units.
Next slide, please. So if you could explain to the commission, they've heard some testimony from witnesses from OCC, but can you describe your experience briefly in secondary and tertiary recovery units in New Mexico and their significance?
Well, I had a client that was putting together 3 different San Andres secondary recovery units. And I felt like I got an education from the engineers at the Petroleum Recovery and Research Center at New Mexico Tech. They were wonderful, but they were consulting on the deal. But it's a huge task. And one of the things that I learned from the PRCC engineers is primary recovery, especially as to the San Andres Formation, is likely to get 30% of the original oil in place. An effective water flood is likely to get 20 or 25% of the 70 that's left. So if you are interested in putting capital into a project, especially one involving hydrocarbons, why wouldn't you want to go where you know that there is porosity, permeability, and oil in place? Those are the 3 things you have to have. And you know that with a secondary recovery unit, because the science tells you that the wells have not been depleted. What the problem is the technology hadn't caught up. And that's why it is such an interesting subject. So in order to do one, even if you've got a 4,000 acre unit put together that may have taken you 2 or 3 years to put together, you don't have a unit operator until all of the working interest owners and all of the operators that have contributed wells to the unit agree to who's going to be the unit operator. Then you have to decide on the formula for allocation of production, which on some water floods can get really wild. But the real problem is you think it's going to work, but you don't know it's going to work. And so you might put together an 80 or a 160 acre pilot program, and your engineers are going to tell you, okay, let's try a 5-spot pattern. And a 5-spot pattern is like the dots on a dice. There is 1 dot in the middle that would be the production well, and the 4 dots on the corner would be the injection wells. And then there'd be another 5-spot next to it, so that the dots on the corner, you can't make the water just go to the center of the 40. So you do this. If you get a response, then you can go ahead and institute full field development. But the bottom line is it's incredibly expensive to do. It takes a lot of time. And without the existing wellbores,
Next slide.
it's not economic.
And yeah, that's good. Describe your thoughts, next slide, please, on the likely consequences of the adoption of the proposed rules on the formation of secondary recovery units.
I think it will be an economic barrier to anybody ever wanting to try a secondary recovery unit again.
And why so?
Just because of the cost of bonding all of those wells until they are converted to injection. Obviously, if they stay a production well, they would have the bond, but it takes a lot of well bores, all of which are, none of which are already injection wells because the unit hadn't been formed. So you're going to have to bond every one of those wells in order to go forward with the plan.
And when you're talking about this testing of the hypothesis, essentially with a single set of injector wells and a production well, what's happening with the other wells in the unit at that point?
If they can make anything, they're making it, but otherwise they're probably T8.
And in your experience with those three secondary recovery units that you had so much involvement in, I take it you probably would not be able to rattle off of every well in that unit sitting here today.
This
do you have
a long time ago.
Do you have a sense of where they would fall in the definition of marginal or not marginal under these rules and no beneficial use or beneficial use?
Unitization?
Yes, sir.
I would say the vast majority would qualify as marginal wells.
All right. Next slide, please, Mr. Everhart. So we have to take a quick step back. I realize that this is moving fast, but in a typical oil and gas lease in New Mexico, what's the term and how is it different for if you establish a gas well production versus oil well production?
Well, most oil and gas leases allow you to explore for oil and or gas. They have a term of years, and after a discovery is made, then the lease is perpetuated for as long as oil or gas is capable of being produced in paying quantities. The distinction between oil wells and gas wells lies in the fact primarily that you can't load up a tanker truck with gas. You have to have a pipeline to take it away. And if you have drilled in a new area of a basin and you make a highly prolific gas well, and then there's no pipeline to take away the gas, you have to avail yourself of what's called the shut-in royalty clause. The shut-in royalty clause is applicable to gas production only. And if gas is capable of being produced but can't be for any of those reasons, lack of a market, that would apply to constraint takeaway as well if you did have a pipeline, then you can shut the well in and pay the lessor the agreed upon shut-in royalty payment that will keep the lease in effect.
Thank you. And moving to the next slide, you talked about constrained takeaway. What are the reasons why an operator might take advantage of the shut-in royalty clause and refuse to produce a well that's productive and hooked up to a midstream gathering system?
because it might, in a low price situation, because the price of gas fluctuates vastly more than the price of oil. It used to be, before the stepping away from coal and using natural gas for electricity generation, it used to be that you could almost plot the price of gas as to what natural gas was, what it was going to be during the winter heating months, as what it's compared to what it's going to be in the summer when it's hot, because the bulk of the gas was used for heating. In that low production environment, it would be economic to shut in the well, pay the shut-in royalty, and wait for prices to improve. And that would benefit not only you and your working interest owners, but also the royalty owners, whether they be federal, state, or fee.
You mentioned historically, have we seen periods of low prices in New Mexico gas productions for reasons other than the seasonal fluctuation more recently?
Yes, the takeaway capacity. That was a huge issue. A couple of years ago, in many cases, you had to pay the gathering system to take your gas. It had a negative value. But if you had been drilling horizontals, Bone Springs, Wolfcamp, whatever wells that made oil and gas, you had to do something with the gas, because otherwise you'd have to shut in a highly productive oil well. So you would pay the freight to have one of the gathering systems or midstreams take your gas off your hands so you could produce your oil.
So what would a prudent operator of a gas well, historically producing gas well, do in those low price environments?
Especially when it's negative, the prevention of waste would dictate that you shut it in.
Right. And what effect would this rulemaking, in your view, have on those sorts of decisions?
I think, as Mr. Armstrong touched on, you don't know when you shut a well in, you don't know how long it's going to be shut in. And the whole proposed amendments focus on lines in the sand, X number of barrels of equivalent, X number of days, and that just doesn't work unless it needs to be on a case-by-case basis, because it doesn't work even just comparing marginal oil wells to marginal gas wells, even though you've got the conversion rate, because they are different animals. And I think Mr. Armstrong touched on this too. Gas wells rely on the pressure from the formation to get the gas out of the wellbore. And in a low production gas well, many operators have found that if they shut it in for a day and then come back a week later and open it back up, the pressure has built up enough to deliver as much or more gas than it would have made on for the whole week. And so that is another area where the prevention of waste would dictate that a prudent operator shut in a gas well.
And you were here for Mr. Armstrong's testimony about constrained takeaway resulting from maintenance or problems with the midstream company.
Exactly, because if midstream goes down, you don't know how long it's going to be down.
And how much control does an operator have over the midstream company?
Zero.
If we can move ahead, it's going to be slide 31 to reworking and recompletion. Would you, one more. There we go. Would you explain to the commission the difference between reworking and recompletion?
Well, they always find themselves in a sentence together with an ampersand, but they're totally different animals. Reworking is going back into the well to the productive zone that you have already established and doing something, either mechanical or chemical or something, in order to increase the production from that zone. It can be a newly designed frac job, a refrac, or just a hot oil job, or
we don't need to be
chemical
exhaustive.
stimulation.
Yeah, let's move on to.
On the other hand, a recompletion is when you go out of the zone that you have been producing into another zone, generally uphole, but it doesn't have to be, and treat it as though it's an initial completion. You perforate it, you acidize it, you frack it if you want to, and if you're lucky, it produces as well as the zone you've left, and so you pull your bridge plug and produce them both together.
How do you accomplish these activities under standard JOA that we talked about?
It is a again, depending on the cost, because as we've established, the JOAs have that cost ceiling beyond which the operator can't spend the non-ops money without their consent. But if it is an expensive one, he would circulate AFEs, and the JOA would give each of the parties 30 or 60 days, 30 in most cases, to elect whether to consent to the operation or not. And then he would go out and find the service companies to do whatever the proposed operation was.
Good. And
Mr. Cloutier, you have about 4 minutes.
And I've got this one and one more issue on direct, and then I've got a very short rebuttal and some sort of rebuttal. Tell the commission briefly how a prudent operator might approach reworking or recompletion without this rulemaking, and how the rulemaking would affect it. Slide, please.
Well, the reworking and recompleting, especially wells that are toward the end of their apparent initial life, is a gamble, because if it doesn't work, then you're going to have to either plug the well or bond the well. If the proposed rules are adopted, that decision is going to be taken out of the operator's hands in most cases, because he won't be able to afford the bond in order to keep the well, to try to do a recompletion or rework.
Objection, Madam Hearing Officer. I think that the financial assurance and who can afford what is way outside of the scope of any provided direct or rebuttal testimony.
Mr. Cloutier, you can certainly.
Can you reword the last bit in light of that objection, Mr. Ezzell? What is the risk to the state of New Mexico, not for all operators, but for some?
Premature abandonment of wells, which is waste.
All right. We've heard in this commission hearing, and you've testified to a little bit about the production paying quantities doctrine. And this is the last issue I want you to talk about. What is it, and how does this rulemaking affect it?
Basically, the rulemaking, if adopted, would conflict with long-established common law principles on the validity of oil and gas leases. The test is whether a well is capable of production. And there was a famous case, the Clifton case in Texas, that has been adopted in New Mexico more than once, that says the test of production in paying quantities is the well capable of production in paying quantities over a given period of time. The Clifton court said at least 12 months, but possibly up to many, many times that. And that is because between price fluctuations and technological advances, and production is not a straight line. Here's how many dollars you're going to get for a 12-month period. It fluctuates based on production and the price of the product.
And so this reasonable period of time can be longer than 12 months under
Yes,
the.
I think the court said up to dozens of years or tens of years.
That concludes Mr. Ezzell's direct testimony. Madam Hearing Officer will move to some brief rebuttal and then Sir rebuttal. So go to 8. Yep. Nope. No, not that one. Yep. All right. Mr. Ezzell, you testified in rebuttal. I think there's been some changes to the rulemaking, but you testified concerning your concerns about the approval of new operators or acquisitions. Can you indicate to the commission what your remaining concerns are after reading applicants 37?
Well,
72, I mean.
The quoted language says it all. Unresolved adjudicated orders and unresolved settlements for any state or federal violation. Well, first of all, I don't know that we have the authority to make other states divulge their violation history, or some states might consider that to be an invasion of individual or corporate privacy laws. But what does unresolved, first of all, what does adjudicated mean? Is it a hearing? Does it have to go to a state director appeal? What does it take? And I can enter into a settlement for a violation with or without it being deemed adjudicated. And if I am performing under that settlement, the violation is still unresolved, but it's like getting a deferred sentence when you on a speeding ticket. If you don't do it again in 6 months, you're good. And so what would we do if another state had an operator that wanted to come here that was in that situation, had made a mistake, had a violation, was in the process of fixing it, and wanted to come here?
We could move 2 more slides, please, Mr. Everhart. We focused on this morning. I don't think you were here with Mr. Winchester, but there's a proposal to amend Rule 19.15.8.9A and got the quoted language up there. What are your concerns with this language?
Well, first of all, proceed with any proposed acquisition. That's probably going to be activity that isn't occurring in New Mexico anyway, or at least one of the parties isn't. And it also causes a problem for me because a big part of the business right now is mergers and acquisitions. And if this proposed rule gets enacted, I think we've heard testimony that it's likely to have a lot of operators want to quit being operators. And so they're going to want to sell their inventory. And that is done in a number of ways, either a private party transaction or the operator that has assets for sale, or the entirety of his assets gets a broker to come in, digitize all of his records, set up a virtual data room, and then open it to bids which are needed to be submitted by such and such date. Now, a strict interpretation of the proposed language would mean every prospective bidder would have to establish financial assurance before they could bid on that package. And nobody would do that. Again, promoting waste.
Thank you, Mr. Ezzell. Madam Hearing Officer, now we'll move to some rebuttal slides that were uploaded and served this morning.
Thank you.
Mr. Ezzell, I'm going to run through these with you. First of all, concerning Mr. Alexander's definition of the term speculative, what comments?
I was actually listening on the Teams meeting to that, and when I heard that, and the definition was something like done based on a guess instead of information. And he had said, you know, we just went to a straight dictionary definition. I went, what dictionary would have used that definition for speculative? And so I started Googling it. I quit watching the Teams meeting and started Googling dictionary.com and found Merriam-Webster Dictionary had his definition as the first definition. And the second definition was bought or done to make a profit in the future. And I'm going, okay. There is absolutely no profit margin in one definition of motive in one definition, and it is only a profit motive in the other definition of speculative, and yet speculative plays a pretty big part in this proposed rulemaking.
All right, next slide, please. Next, concerning Mr. Alexander's testimony regarding inactive wells generally being put back in use within 8 years. What comments do you have regarding that testimony?
Well, I think he focused on high demand or decline curves on horizontal wells. And this kind of goes back to my testimony on secondary and tertiary recovery, is when all the shale horizons have done their best, producers and operators are going to want to go back to the old vertical fields and recover and go back to recover the oil that they know is there. And hopefully the technology will advance that will make it easier to get greater ultimate recoveries out of these old vertical formations.
And what effect do you think that has on the 8-year testimony that Mr. Alexander proffered?
I don't know what he based that on, but
well, let me ask.
8 could go much longer in my view.
That's the point I was looking for. Thank you, Mr. Ezzell. Next slide, please. Mr. Morgan commented regarding the collateral requirements for financial assurances, and I think that Mr. Gilstrap today testified concerning basically sureties wanting either cash or letters of credit. How would a standard operator, in your experience, be able to obtain a letter of credit, and what effects would that have on the operations?
If the operator had to increase the cost of bonding drastically, he would have to either access his line of credit, which, by the way, is almost guaranteed to have been already pledged to securitize that line of credit, and then go try to get a surety that would either agree to be in second position on the same collateral, or that would top his bank into being into second position on the same collateral. And that's not going to happen.
And what would happen to the operator's line of credit if the bank issued a, say, irrevocable letter of credit on that line of credit? What would happen? What effect would that have on an operator? Why do they have a line of credit, and what would happen reducing it with a?
Well, then he wouldn't have the cash on hand to do any development.
Thank you.
That he would be required to do in order to keep the wells that he just bonded from becoming more marginal.
Thank you. Next slide, please. This is a two-part slide, but we're showing the portions of applicants exhibit 72 concerning the changes to 19.15.8.9E, and in particular, the strikeout language beginning on the third line of E. What do you understand the effect of that strikeout to be on the inactive wells and approved and expired temporary abandoned status wells?
Well, it looks like just by reading it that that federal wells would no longer be excluded from the proposed rulemaking.
And if you'd show the next slide, explain to the commission why you believe that. And call your attention to the language just before the red in subparagraph A of the same rulemaking.
Yeah. And that is, but if it is covered by a federally required bond, but they are not allowed to proceed with any proposed drilling until it's furnished the financial assurance. And that looks like it's asking for it twice.
The objection, I know we're at the end here, but what is he rebutting?
This is the testimony that federal wells are exempt from the rulemaking. That I think.
Well, then optional completeness, I would ask the part that says unless the well is covered by federally required financial assurance be read into the record.
And that's the language we're focusing on. And what is the effect of striking the reference to this subsection in the prior section, Mr. Ezzell?
If that subsection is stricken, it's not in the regulation anymore.
As to those wells covered by subsection E? We can move to slide number 7 here. Mr. Purvis and Mr. Morgan offered testimony about single well bonds or using a single instrument if the operator's portfolio increased to this 15% threshold that you heard Mr. Armstrong testifying about. What observation do you have about that testimony?
Well, if you are required to have single well bonds and you find a surety that will do it for you and put it all under one instrument, that makes it a blanket bond.
Thank you. There was a question, next slide, posed by Commissioner Bloom to a witness about the use of the permanent fund to plug and abandon wells. Do you have any additional color to add to that?
It can't be.
Why not?
Well, the permanent fund is constitutionally created, and the beneficiaries and the amounts that they get are constitutionally dictated, and it would take a constitutional amendment. And I know we're happy to do those every once in a while, but it would take another constitutional amendment to raid the permanent fund again for this purpose.
Thank you. Next slide. Mr. Pell offered commentary that the rulemaking would prevent waste by forcing operators to plug low producing wells to either they or a different operator develop other horizons. What do you think about that theory of the rulemaking preventing waste?
I think they're looking pretty hard for a peg to hang. We prevent waste too on. If the low plugging, if the low producing well can be produced economically, it needs to be produced until it can't. And, you know, it may be a part of the plan that those wells are holding the lease for the same operator to come in and do that development. But it's his property, it's that operator's property right. And if they're using that well to hold a lease, that's their contractual right to do.
What happens to the oil and gas in place in a different horizon, if there is any, while the operator is producing the low producing well from another horizon?
It's still there.
Does it disappear over the course of time?
Nope. But if the other well gets plugged, it might get left in the ground. And I know that's a term we don't like to use.
All right, next slide, please. Mr. Powell offered a very similar theory about protecting correlative rights by allowing the other owners of the interests in the minerals to have their other minerals developed. Do you have any comments on that?
Well, the non-op